Good morning, everybody. We're going to call to order this Thursday, June the 18th, 2015 meeting of the Tennessee Alarm Systems Contractors Board. Ms. Fess, will you please call the roll?
Thank you. Scott Kaufroff,
Here.
Keith Harvey,
Here.
Vivian Hickson,
Here.
Karen Jones,
Here.
Mackenzie Roberts.
Here.
You have a quorum, Madam Chair.
Thank you. Have the members of the board had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
Make a motion to adopt the agenda as presented.
Second.
We have a motion by Mr. Harvey and a second by Mr. Roberts to adopt today's agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. The next item is the minutes from our March the 19th, 2015 board meeting. Have the members had an opportunity to review those minutes, and if so, a motion to approve?
Madam Chairman, I make a motion to approve the minutes as they were submitted.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to approve the minutes as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. The next item on our agenda is the election of officers for the board.
Okay, I get to do this time. We're opening the floor for nominations for board chair.
I make a nomination for Vivian Hickson as our chairman.
Are there any other nominations? Have a motion that
I make a motion that
nomination-
the nomination cease and we elect Ms. Hickson by acclamation.
Second.
Vivian, you've been elected the board chair by acclamation.
We probably need to vote on that.
Oh, yeah, I thought you did, sorry. And the vote?
All in favor? Aye.
Any opposed?
Make a motion that the nomination cease and we will elect Karen Jones by acclamation.
Second.
Aye.
Aye.
Any opposed? Okay, you've now elected.
Next item on our agenda is the legal report. Mr. Glandorf.
First, I'd like to introduce you all to Miss Ashley Thomas, who's sitting next to me. Is an attorney who we just recently hired this week here at the Department of Commerce and Insurance. She's going to be assigned to your board. So she's here today to observe our first meeting and to see how the process runs. Ms. Thomas previously worked at Department of Human Services. She was there for 5 years, and she was assigned as an administrative judge, which is also a hearing officer. So she's very much in tune with the regulatory scheme of the Uniform Administrative Procedures Act and about the disposition of matters that come before state agencies. So we're very excited to have her on board here today, and I look forward to being able to work with her and some of the other attorneys in the office to get her situated and within our department.
Thank you.
I'll go ahead and start in reading the legal report. And the same caveat as always, that if you all, regarding the discussions of the recommendations and all of that, is that I'll be happy to answer any questions that I can. Case number 2015-006951. Here, there was a complaint that alleged the respondent alarm company failed to display its alarm certification on its website. A printout of the company's website shows that the respondent did not include their certification number. The respondent replied stating that the company was in the process of updating it and failed to display their number on the website. They state they have corrected it and apologized for the oversight, and our department went ahead and checked, and we found that they did in fact have it corrected. So here we recommended, and recommendation is for a letter of warning.
Okay, we have a recommendation from our counsel, legal counsel, to authorize a letter of warning in this matter. Do we have a motion on it?
I make a motion to concur with council.
Second.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 2 is case number 2015-005491. Here the complaint alleges unlicensed activity by respondent company. The complaint was opened when the board received a complaint from a licensed alarm company alleging respondent was awarded a contract with Nashville MTA to install access control and video surveillance equipment. The respondent is not licensed, nor do they apply for any exclusions. The complaint submitted an email which was sent to them from Nashville MTA informing the complaint that the contract was awarded to the respondent's company. The respondents state that they had operated in the state of Alabama as a general contractor with an unlimited rating of this type. The respondent states that they then reviewed our rules and regulations regarding contracting in Tennessee and our licensure statutes and have withdrawn from their consideration from the MTA project. Given that, our recommendation is for authorization of a letter of warning.
Make a motion to concur with council's decision.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Roberts to concur with their council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 3, case number 2015-005001. Here the complaint alleges that the respondent company failed to list their certification number on an advertisement. The complaint was sent to the board, which included a picture of the respondent's advertisement that did not include the certification number. The respondent stated that as soon as they received this notification, they did an investigation, found out that they had purchased some stickers that failed to have the alarm certification on it. They immediately disposed of those and are correcting the sticker. The respondent apologized for the oversight and immediately corrected. Given this, our recommendation was for a letter of warning.
Madam Chairman, I make a motion that we concur with the recommendation of our council.
Second.
If we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 4, case number 2015-004991. Here the complainant alleges that the respondent company failed to list their alarm certification number on an advertisement. The board received a copy of the advertisement with a picture of a work van that did not include the certification number. The respondent states that they were not aware that this had to be displayed on all advertisements, and then they indicated that they immediately altered the sign to include their certification number. Recommendation is authorization for a letter of warning.
Okay, we have a motion by Ms. Jones. Do we have a second?
Second.
By Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 5, case number 2015-004981. Here in this complaint, it's a consumer complaint alleging misconduct by the respondent. The complainant stated that he received a letter from the respondent stating that an upgrade was needed to continue their service. The complainant states that the price of the service had increased twice before, so he wrote, cancel on the letter and sent the letter back to the respondent. However, he states the account was never canceled. The complainant stopped his automatic account payments, and he continued to try to cancel his account, but received numerous reasons as to why it could not be canceled, even though it had expired in 2012. The complainant alleges that he is receiving past due invoices. The respondent wrote stating that the complainant wrote the word cancel on an invoice, which was then mailed to a payment center, which was put into a lockbox at a bank. The respondent stated that this is not the proper notice to cancel an account and states there's no guarantee if or when the respondent will receive the letter from the bank. The respondent does confirm that the complainant has since called to cancel his account, but the cancellation was not processed, and this led to the account eventually closing for non-payment. The respondent states that it has reversed the balance due on the complainant's account and closed his account in good standing with a zero balance. The respondent states a letter was mailed to the complainant to inform him of the resolution. The respondent included this letter with his written response. My recommendation is to close.
Make a motion to concur with counsel. Is this a civil matter?
Okay.
Second.
We have a motion by Mr. Harvey, a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 6, this is case number 2014-028-281. Here, the complaint alleged that the respondent failed to register alarm employees within 30 days from the employment date in violation of TCA 6232-312. The board received an anonymous complaint which listed 4 employees who were working for the respondent companies without a valid registration. Upon receiving that, we sent one of our investigators out there who completed investigation and found that there were, in fact, a total of 7 employees who the respondent company were found to be working without valid registrations. However, some of those currently do have registrations, but we found that they had not been registered at certain times in their employment. You can see listed there 1 through 7. These are the employee ID numbers, the license numbers for those who are licensed, and then those that are currently employees who do not have licenses. The respondent company states that all of their tech started out doing phone cables, data intercoms, and programs into alarm pre-wires, and most techs work with their electrical division. The respondent company states that they're a small company, and during the course of activities, they had failed to register their employees in a timely manner. They did admit to that. The respondent company states that they had been an oversight on their part, and they apologized for this oversight. So what we did is on 1 through 7, just to give you a summary of those, is that we took for those employees who currently had a license, we took their hiring date and then the date of their actual licensure, and we calculated those months, and then we subtracted off the first month of the 30 days, so that gives the resulting months that you see there on the the right-hand side on number 1 through 7, which totals 119 months, and going through the board's normal penalties for these such violations of $50 a month, our recommendation is a civil penalty in the amount of $5,950.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
We have a motion by Mr. Roberts, a second by Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 7, this is case number 2014-03911. Here, the complaint alleged that the respondent was awarded a bid for installing CCTVs for the Sparta White County E911. An investigation was completed by our office on the alleged activity. The investigator spoke with the director of operations for the White County E911. The director stated that her employer had used the respondent for computer repair and had known him to be trustworthy and dependable. The respondent placed the bid for installing the cameras and won the bid. The director stated that her employer bought all of the equipment and the respondent merely performed the labor. The investigator spoke with the respondent admitting to installing the cameras and told investigator that he did not know he was breaking rules by doing this. The respondent goes on to say that he never sold, installed, or monitored alarm systems, signal devices, burglar or fire alarm systems. The respondent states in the past 5 years he has done maybe 4 or 5 jobs of installing cameras. The respondent installed 10 cameras for the White County E911 Center and was paid $1,300. Given this, we recommend authorization for a civil penalty via consent order and authorization $500.
Curious, was this person planning to get a license and do this business, or was this just something on the side he was doing, or?
I don't have any information here that talks about the respondents want to receive a license in the future. That was not addressed and that was not included, that information in the investigation.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Okay, we have a motion by Mr. Roberts. Do we have a second?
I'll second.
And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 8, case number 2015003291. This is a consumer complaint that alleged misconduct by the respondent. The complainant alleges that the respondent installed a security system, and sometime after the installation that the system failed to work. The complainant alleged that the respondent will not fix the system nor return any of the money so he can hire someone else to fix it. The respondent states that at the time of the installation, the equipment was tested and that it worked properly. The respondent states that he had been delayed in returning to the complainant's home to re-inspect the equipment due to bad weather and the passing of a family member, and that the respondent states that they refunded $500 to the complainant. Our recommendation was to close. The respondent refunded complainant $500. There's no other further violations that we could find.
Do we have any information back from the complainant that they felt like that was a reasonable settlement given the circumstances?
No, we don't have. I don't have any information here where the complainant wrote back any of that information. Any information as to whether or not they were satisfied with that or not.
Excuse me, has it been several months since this refund was issued that the complainant would have had ample time to notify you if it wasn't to their satisfaction? I know it says bad weather and so forth, so I thought it might have been something that originated a few months ago.
That was sent. Initial response was in March. The original complaint came in January. February. It came in early February. So we received information regarding the refund, involving the refund back in March. And we
The
haven't received any
complainant.
information from the complainant.
Okay. Have a motion on this?
Madam Chairman, I make a motion we concur with the recommendation of our council and close this particular instance given the apparent settlement with the complainant and this issue.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 9, this involves two cases, 2015-004711 and 2015-004691. Here, this complaint alleges respondent failed to notify the qualifying agent termination within 10 days in violation of Rule 90-01-.07. Qualifying agent was terminated on October 1, 2014, and the termination notice was by the board approximately December 17th, The respondent states when a qualifying agent was terminated, a call was placed to the alarm board to inquire what to do. The respondent states an alarm board employee notified they needed to send notice of the termination. The respondent states a letter was sent notifying of the termination, but did not realize they needed to send an official termination form instead of a general letter. The respondent apologized and states they are still learning the process for the board's guidance. Our recommendation was for respondent 1, which is the company, a civil penalty amount of $250, and as to respondent 2 is the DQA, which is $50 civil penalty.
Actually, did we receive the letter that they're saying they sent a letter versus the form?
Yes, we actually received a letter.
Timely within the,
It was stamped October 30th.
Madam Chairman, I make a motion that we authorize a formal hearing and send a consent order to both Respondent 1 and Respondent 2, a civil penalty in the amount of $50.
For each.
Yes, for $50 for Respondent number 1 and $50 for Respondent number 2. And the reason I would do that, it would appear to me that the company tried to comply in good faith, and although I think some penalty would be reasonable, it would appear to me that they were trying to do what was right, and I think $50 fine would, or a $50 civil penalty would be more appropriate.
A second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to concur with our council's recommendation in this matter, except for to reduce the civil penalty on Respondent 1 to $50 from $250, and the other remains the same. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 10, case number 2015003851. Here, this complaint is a consumer complaint that alleges misconduct by the respondent. The complaint's alarm system had called an alarm to the fire department, and complaint states the alarm was not even activated at the time. The complaint notified the respondent company. The next day of this activity, respondent company confirmed that they received multiple alarms from complainant's telephone number the day before. The complaint states he was told by respondent company that a service technician would need to come out to check the system and to fix any problems, and is told at the time he would be charged $95. The technician told the complainant there was no internal problem that could be found. The complainant feels that since no problem was found, he should not be charged for the service call. The complainant canceled his monitoring service with the company. The complainant requested a refund for the unused portion of a $180 payment made in advance on a yearly basis. The complainant states he still has not received a refund. The respondent states that the complainant did in fact call the company and asked that the charge for the service be voided. The respondent company told complainant that the service call could not be voided, and complainant became upset and demanded his service canceled and demanded a refund. The complainant was instructed to cancel in writing as per the contract agreement so that it would not renew the contract. Which is an annual agreement. The respondent company agreed to cancel his monitoring service but does not offer refunds if services is not canceled before the annual renewal. Respondent states the complainant is now trying to pay for the invoice for the service call by deducting the balance of his annual monitoring bill. The respondent states service calls and monitoring are two completely different bills. The respondent company states they tried working with the complainant but cannot charge for a service and stay in but they cannot charge for a service and stay in business at the same time. So I recommend that we close this complaint. It appears to be a contractual dispute. There's no evidence that we had any fraud or deception that was found on the part of the respondent.
I'll second.
Okay, if we have a motion by Mr. Harvey, a second by Ms. Jones to concur with our council, all in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Would it be possible to skip number 11 and come back? Because I think that may be, we may have a discussion on that. Okay. So we'll skip to 12 and come back to 11. Number 12 is case number 2015-003841. Here, the complaint alleges unlicensed activity by the respondent in violation of 6232-304. The respondent company viewed the processes that another company was conducting for the installation of one chain store. The respondent viewed processes as to advising on how to bid for the job and to advise the company on what would be required. The respondent did not sell a service system when giving the advice. The respondent applied for licensure in order to bid for the job. My analysis, it doesn't appear that there was a violation of 304K because though they advised, they did not sell or attempt to sell a service or product. I recommend giving this authorize a letter of instruction to respondent instructing that if they sell or attempt to sell, they would require licensure.
Ask a question. Isn't, and I don't recall the particular paragraph without referring back to it, but doesn't it also include an advisory statement as well?
But in looking at the statute, 304K is a specific one that I was looking at. The prohibitive activity requires that there be two things, and it says no person shall advise anyone as to the need, quantity, or quality of alarm systems and sell the systems unless certified. So they only did one. They advised but not sell. And when I actually spoke with the owner on the phone, he indicated that they're from North Carolina. They were paid just to advise them on how to bid it out, and that they intended to be a part of the bid, but they were not going to do that until they get licensed. So that was their understanding. So in looking at that, the way that I read the statute is that they've only done one of the two required activities for it to be a violation.
I think I would agree with you. Thank you for the clarification. Madam Chairman, I make a motion we concur with the recommendation of our council.
Okay, we have a motion by Mr. Roberts. Do we have a second? Second. By Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 13, case number 2015007831. This complaint alleges a lack of good moral character by the respondent in violation of 6232-319. Parenthetical 4 here, the respondent was a deputy sheriff and was working at an inmate facility. Respondent was arrested January 29th for having, it says, indicates sexual contact with an inmate. The respondent was found guilty of such on March 25th. The judgment for respondent provides 100 hours of community service and a year of probation under a pretrial diversion. The alarm company the respondent works for stated they believe respondent's actions would not have been an offense if he was not a deputy sheriff, which does not in any way affect his ability to continue in the alarm industry in his current capacity as a qualified agent. The company goes on to say that it would be an extraordinary hardship for on the respondent's ability to support himself and his children since the alarm industry is his sole source of income. Our recommendation is authorization for a civil penalty in the amount of $500 for a violation of 6232-319A4 regarding a conviction lacking good moral character.
Madam Chairman, I must recluse myself from this particular issue.
Charged for sexual contact. Was that a felony?
It was a Class C felony, and actually this is a type of Class C felony that is allowed, and I have to get the file, that allowed for a pretrial diversion.
She is in the process of going through probation now.
Yes, it's a probationary only right now, and under pretrial it should qualify for an expungement in the future if they finish that, which means that if that be the fact, that it would be completely erased in the future.
How long the expungement period is and how far he is into it at this point?
It would have been conviction was, it started in March 25th, so it would be approximately, I believe, I believe it's approximately for 1 year, so it would be going forward from that time. I'm trying to get to the file as I talk to you, I'm sorry.
Would something like this typically involve a civil penalty versus, I thought it would have been brought to the board just in relation to whether or not to continue as a red.
The statute allows, it's a prohibited activity, which the statute allows for. The discretion is there could be a denial, could be a denial, suspension or revocation of the license under the statute, but any violations of the statutes can equal a civil penalty. So given that the court systems found that this actually qualified for pretrial diversion, and the court was willing to accept the pretrial diversion in the district attorney's office at the same time, that potentially could be expunged, then I felt that it would be more appropriate for a civil penalty, given that more than likely he will finish the pretrial diversion. For all intents and purposes, this conviction will be erased. So that it wouldn't even be on his record. So I was trying to find consistency within the state agencies as to how this was dealt with. That's why my recommendation was a civil penalty. Actually, this didn't even involve my understanding, this did not involve his profession in the alarm industry. So I was very hesitant to recommend anything other than a civil penalty.
He didn't commit the crime while he was installing an alarm.
Correct. Yes, that's my understanding. That is correct.
Well, I would like to make a motion here for discussion purposes. I would like to make a motion that actually suspend this alarm license until the period of probation and pretrial diversion is over to see the outcome of that. I'm kind of opening that up for discussion. Do we have the ability? I know we've looked at this thing in the past. It's a sticky area for us to suspend a license. What is the proper channel of what we should do in that situation? Because I know it's hard for us to put it on hold.
Oh, I'm sorry. You weren't addressing that to me, were you?
Anybody who knows the answer, really.
The suspension of a license is something that the board could authorize, such as a civil penalty or anything else. Your authorization would authorize that to be done through a formal hearing process. So what would happen is we would send out a consent order for a voluntary suspension of license until the end of this happened. If the respondent at that time did not want to agree to a suspension of that person's license, then it would be on our office and department to actually file formal charges and to have a formal hearing in this matter. And that would be set for a future date, and then they could sit before the board or administrative law judge, and there would be a determination made on that suspension. And given your authorization here would be a suspension until the end of the 1 year period, it's very possible that the hearing could take place in the future that is very near the end of that suspension date. So I just have I'm not sure if that actually would effectuate what you're trying to do.
Well, I think where we opened to this case was with allegation of lack of good moral character, and a person that was not only sentenced but convicted of a sexual act against another person. I would tend to agree.
And what I should clarify that the statute regarding this is not a sexual assault statute, just for clarification. It could be consensual touching. It does not have to be a non-consensual touching. It basically is a crime against not the person. It's a crime against administration of the government, and it has to do with thank you. Yes, it's an inappropriate behavior and conduct of a governmental official or employee is where it comes under. So that's why it was actually qualified for a pretrial diversion, because it's not an assault. Now, your statutes indicate here, and I will point this out, that you have a definition regarding what is and is not good moral character, and it lists certain crimes and events that fall into those categories. However, it leaves the door open for there to be other crimes, and the crimes regarding good moral character are those regarding the use, possession, sale, manufacture, distribution of controlled substances, drugs, and narcotics, any types of felonious assaults, unlawful breaking and entering, burglary, larceny, conviction of habitual criminal as being a habitual criminal, or addiction to alcohol, drugs, or narcotics. This is not specifically mentioned in the statute. However, the statute leaves the door open that it can have other crimes for you all to be considered crimes involving a lack of good moral character. Given that this actual criminal violation is under the administration of the government and conduct of a governmental employee or official, it appears in my analysis that it could be considered to be a lack of good moral character.
That's what the statute leads with, isn't it? Good moral character, and then starts out with a felony conviction.
Yes, that's under your statutes. The conviction, what he was convicted of, is not specifically listed down there, but it has to do with conduct of a governmental official or employee. And so I don't want you all to think that we received a complaint from an actual individual with details as to what actually happened. It was a self-notification from the individual that they had been arrested, and then they later took a plea agreement for this type of for this conviction.
Self-notification, you said,
We received a letter from the respondent.
but it did the respondent turn himself in? Is that how he or she got caught?
Oh, I do not know the details of how.
Oh, I
how
thought that's what you were.
No, I'm sorry. It was self-notification
leading
to
to.
us. Sorry, it was from the company to the board.
Question for me, I guess, is still more whether or not the person continues in the job. The civil penalty is not as big of an issue for me as it is whether this person should continue working during this period of time. I think that's the bigger question. They're saying that it puts a hardship on them because I guess it's their primary source of income at this point. No longer employed in the other position that.
I was a deputy sheriff. We didn't receive details of that as a deputy. I'm sorry, I didn't receive details from that.
Oh, I'm sorry.
I'm at a bit of a loss as to how to respond. The person in question is my son, and so it's difficult to be unbiased in that particular situation. However, if there are any questions that I can answer factually, I would be, if counsel feels that would be appropriate, I would be willing to do so.
Well, I think,
Excuse me, but
go ahead.
what have we traditionally done in the past? I guess is where you're having a
Well,
problem with
that's
this,
what I was getting
with the
ready to
pretrial
say. I
diversion.
don't know that I don't recall a specific instance like this, but when we've had someone apply to be a registered employee and they were on probation, we've delayed approving their registered employee application until they successfully completed their probationary period. And that's been the path that the board normally takes when we have a matter like that, which to me is very similar to this. You know, you have an employee, or I think did y'all say it was a QA in this case, that's now on probation for, a felony. And they've got, 9 months, I think you said, probably left on their probation.
Yes.
I see it more from the suspension side, from the alarm industry, versus the penalty part of it.
I would ask that, Mr. Roberts, if you do not vote on this matter, if you recuse yourself from the voting of this matter, you may have some facts that you could provide to the board members. However, it appears now that this board, I would inform you all that you now are aware as to who the respondent is. So I would, in the future, if this went to a formal hearing, that I would ask that you as a board not sit and make a determination, but we would have to do it in front of administrative law judge only.
Well, I apologize to the board if I inappropriately disclosed the relationship there. Again, I'd be happy to answer any questions. I think, frankly, I think counsel has well presented the case appropriately. The point that it was self-disclosed indicated that there was not a complaint from any outside entity, but this was appropriately disclosed by the person who was a qualified agent. Sent a letter outlining the details, providing all of the information that has been presented. Basically wrote a letter saying, look, this is what's happened. He's on probation. It's a pretrial diversion, which I'm not sure technically that's a conviction. Maybe counsel would want to address that, but I'm not well versed in that arena.
Have your to address that, this board has their own statute regarding conviction that it says here, for purposes of regarding good moral character, conviction means it includes an entry of a plea of guilty, plea of no contest, or a verdict rendered in open court by a judge or jury.
Again, I think counsel has presented the case very fairly. I'd be happy to answer any questions the board might have.
Let me ask you, counsel. When I first started this, your reply was you did not think that a suspension would render what I was after there. Exactly what did you mean by that?
Well, and here's the issue: is that we could. You wanted what it appears that what you would say is that you would want a suspension until, say, the end of the probation period. Well, if you want to go forward with that and we did a formal hearing and we would request what you would ask for is until the end of the probation period, that individual would still be working all the way until up to the hearing date. And then if the judge did say, okay, we're going to suspend your license until that, then it may be a 3-month period, let's just say, by the time we have a hearing and whatnot. And then he has so your suspension may only actually be for 3 months at that point in time. And the part, so I mean that may be, you may not be, it looks like you want a suspension now for the next 9 months, and that's just not possible unless you summarily suspended the license. And I don't find that there's facts here to allow for immediate potential harm to the public. That's just where that's at. Now, if worst case scenario, if a formal hearing couldn't be had, if we could not file charges if we couldn't have a hearing until in the future, we actually have a difficulty in actually putting on proof as to whether or not this conviction actually happened, if it is in fact expunged, because under state law, this department would not be able to house any piece of paper, document, or make a statement regarding the conviction in the future. So that's why I pause when it's on pretrial diversion near expungement, because the intent of the legislature is to indicate that this never actually happened in the future, if that be the case.
I asked that question about self-reporting, did you say? I thought you meant that the respondent turned himself in to law officials instead of the inmate. Who told on who, the inmate or or the deputy?
Oh, I don't know that. I don't know the facts of that. No, I believe that. I do not know. I don't know if. No, I don't. I don't have that. No, I meant.
Because the self-reporting in this matter is that the QA self-reported to the state
Yes.
the incident.
Yes, the incident came to us from the respondent and respondent's company.
Okay.
We had no knowledge of it other than from them.
When did
Well,
you
let me
receive the
say
letter?
Something, you,
I'm sorry,
you
we
can
were-
still do the $500 and you could do a litigation monitoring and put him on probation to the end of the,
Where I was about to go with this was if I don't really want to word it like this, but if we didn't do anything this moment until the pretrial diversion was completed, would this automatically come back to us, or can we request for it to come back to us once that pretrial is completed and we see the outcome of it?
Yes. Okay. So I think this is what Cody was mentioning. Maybe more what you're talking about, which is a litigation monitoring consent order, and that's an authorization that we could do, which would basically do this. You could do a civil penalty and a litigation monitoring order, which would be an order that we would ask the respondent to sign, saying that that he's not necessarily on a probationary status right now with the board, but that we will monitor the outcome of his probation, and that when he finishes the probation, he's required to give us the disposition of the probation, such as successfully completed the probation or not. So if he does not, and there is actually a conviction and it stands, then this board could go forward and say, oh, well, we can summarily suspend your license because you have a conviction that now that's going to stand. And if he actually finishes the probation and actually applies for and receives the, and indicates that they're applying for the expungement, then that could be where we could bring it back to the board, and we would probably recommend at that point in time that we close it, since we can't actually talk about someone's actual expungement before in these meetings. That's what it would be called a
I
consent
personally
monitoring.
would be comfortable with that type of situation myself. I don't know that I fully understand or even see the purpose of the civil penalty in this particular situation, when our focus is really more on the outcome.
And the reason for the civil penalty, I'll just say, is that a litigation consent order, a monitoring consent order, is not official discipline by the board. For all intents and purposes, if we did that and somebody asked, well, was this individual disciplined by the board, we'd say no. We have a monitoring order in place as though pending whether or not we're going to have future discipline. However, if we do a civil penalty, then he would actually be this person would be actually officially disciplined by the board for this issue at this point in time. Now, you could defer that discipline until the outcome in the future, but it's very possible that in the future, if it had been completed completely, then we'd recommend that since it would be expunged, that there actually is no discipline, put it on the record. So the opportunity for discipline is actually official discipline is actually now that you can do that. That's why I recommended a civil penalty.
So that's in our best interest from a board perspective.
Well, from the perspective of, from high up policy perspective, is that discipline is that when you have on the record that you have actually disciplined an individual, that is open to the public, and that provides the public with information that they can look up on the individual if they felt in the future. So it's a protectionism to for the consumers. If there is no discipline rendered, then the public is not notified. It has no notice, the ability to know that this was an issue that was brought up to the board. So I think it's more appropriate to take disciplinary actions if you find a violation here.
So would you feel more comfortable to leave the civil penalty in place and put the litigation monitoring on there as a secondary?
Once again, is just, to me, this is more of a symbolic issue. I don't, with me not completely agreeing with the civil penalty at all at this point, I would even be fine with deferring it to the end. But if we feel like that's in our best interest, I would recommend the civil penalty be $100, and let's see what the outcome of the pretrial diversion is.
Litigation monitoring, correct?
Yeah.
Okay. Is that your motion?
I would like to amend my original motion to state that.
Okay. Mr. Harvey's motion is that we authorize a civil penalty in the amount of $100 down from $500 for violation of TCA 6232-319A4, having been convicted of a crime indicating a lack of good moral character, and authorize litigation monitoring until the completion of the probationary period. Do we have a second?
Second.
We have a motion and a second. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 14, this is case number 2015006941. Here, this complaint alleges that the respondent, who is a qualifying agent, failed to list one registered employee on the company's 2014 renewal form. The respondent states that the registered employee was not on the list, and the employee's duties did not include working in Tennessee. The employee's workstation was in a Knoxville office, but he was assigned to a western part of North America, not in Tennessee. The respondent states that when the termination notices were sent via email in August 2014, the employee was not included since he was not included on the last renewal, and it was thought that his duties did not require being registered in Tennessee. The respondent apologized for this error and goes on to say the company would like to keep the employee registered in Tennessee. Recommendation is authorization for a letter of warning.
Motion to concur with council's recommendation.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Roberts to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Are we going to go to the representments for number 11?
I would like to go to representments first.
Okay.
Yes, thank you. Okay, case number 2015003281. We had previously brought this to you where a complaint and alleged unlicensed activity on a part of a respondent. The respondent is located in Texas, but is monitoring alarm systems via live video feed for a car dealership in Memphis. Our previous recommendation, you had authorized us a civil penalty in amount of $500 and asked us per month that they had been monitoring, and asked us to go back and obtain proof of that and authorization. If we didn't actually have proof of months, that we could go ahead and close it. Well, we called back and we talked to the general manager. His name is listed there, and then we followed up by mail, and the general manager indicated that they had monitored for 6 years and 11 months. I was very skeptical to write a civil penalty in the amount of $500 per month at 6 years and 11 months to this company without bringing it back to the board to get your authorization, because that total civil penalty would be very significant, and I wanted to make sure that if that's a civil penalty that you actually wanted, that the board had the opportunity to state that very clearly. I did not anticipate that it was going to be for years, that it was only going to be for months. My discussion is whether or not you wanted to make a cap on the civil penalties or how you would like to proceed on that.
The central station is who we levied this against. Is that correct?
I believe so, and yes, it would be in they're in Texas, a company out of Texas, and we received information right after they had canceled their contract that they had been working there, and it was kind of an anonymous type complaint, so they must have known that they had been monitoring and then stopped and whatnot. So yes, but they're out of Texas, and the response to us was very straightforward. It was almost 2 sentences. We do not monitor in the state of Tennessee. Thank you. Was their response to us. That's why we thought that was a little
But
bit
they
strange.
had been since 2008?
They said we currently do not monitor
Oh,
in the state of
currently do
Tennessee.
not,
That's
yeah.
exactly, which was a true statement at the time. That's why we went back to verify with that dealership, and that's what we found, that it was actually 6 years, 11 months.
I don't see how you could put a cap on a civil penalty. You're just sending a message to Texas and Montana and whomever. Let's go to Tennessee and work. They don't.
I wanted to make sure that if I
They
wanted to
don't
bring it
cost
back.
us nothing to work there.
Right. When I understand, and I'm not advocating for the cap of a civil penalty. I wanted to make, when I brought this to you, I thought we were going to be talking of months was the civil penalty amount that I was imagining. So if I was going to send a civil penalty out for an amount approximately $40,000, that it was a civil penalty that the board actually intended to send out. So.
Madam Chairman, if I may, first of all, I'd like to express appreciation to council for exercising some discretion here. I think that was well done and appropriate. I appreciate that. But to follow on, I would make a motion that we authorize a formal hearing and send a consent order to the respondent with a civil penalty of $5,000. Feeling that figure would be more appropriate given the length of time, the circumstances, and again, I appreciate our council bringing, exercising some discretion in the exercise of the board's activities.
And we just authorized one that was in excess of that for somebody that is licensed. It was just related to their employees. So
Registrations.
right. I mean, there was a license. So if they were licensed and their employees weren't, we would be greater than this. I don't know that the 500 per month, but I think something between the two. Yeah, it's
When you got a company paying for 8 employees faithfully,
right.
and then they leave 4 off, and they get a $59.50 fine, and then this company whom knows they done wrong, we do not monitor in Tennessee anymore.
Right, and then, yeah, they didn't even admit that when they were questioned, and we're going on good faith that that they aren't anymore, that this was the only customer.
We can't monitor their internet feed.
One thing we have to consider as a board, this being an out-of-town company that we do not have licensed, if the fee is too outrageous, history will tell us that they're simply not going to pay it. They're going to stub their nose at it. Even if we reduce the fine itself or the civil penalty down to $100 per month, you're looking at a $7,100 civil penalty. Pretty reasonable. I'm sorry. 80.
83 months at $100.
I'm sorry, I had figured my notes wrong. I think that's at $100 per month, $8,300. I think that's
In the form of
Reasonable.
a motion, since my motion wasn't seconded.
It wasn't sent.
so
We
you
didn't
don't need
get
to
a
amend
second
your
to it.
motion. I would make a motion that we level a civil penalty of $8,300, and that would be for $100 per month of unlicensed activity.
If I may, let me add to that, to your motion, that the alarm contracting board or its equivalent in the state of Texas also be notified as a result of our actions.
Absolutely.
Now, as long as, if they don't pay that penalty, if they were to try to get licensed in Tennessee, the flag would come up correct that they had an outstanding penalty. So until they would pay that, they couldn't get licensed if they wanted to.
If one of us would remember that, because they're not a licensed company, because therefore they won't be on our radar and won't be on our computer system.
Beth never forgets anything. So
He's not going to ever leave, so. And then we have Miss Ashley over here. She's new, so she'll last longer than all of us.
Second, all of that.
Okay.
Ken's motion, number 1.
So if I understand correctly, we're going to amend the original recommendation motion to authorize a formal and send a consent order to the respondent in Texas with a civil penalty in the amount of $100 per month of violation of Tennessee Code Annotated 6232-304A for a total of 83 months of monitoring activity as unlicensed, correct? All right, all in favor, voice by saying aye.
And that we will notify the state of
Yes,
Texas of
and
our
that-
actions.
Correct. And somehow flag this in the event they would ever apply here. Okay, with all that being said, all in favor, voice by saying aye.
Aye.
All opposed? The motion carries. That's the only representment you've got, isn't it?
There's actually, it should be a page, if you turn page 11, you have a document
Got it,
there. Okay,
okay.
so this is a memorandum from Ms. Shalina Brown, and she is in the audience with us if you have any questions from her. She's our a litigator for our department, does very well, and we really appreciate having Shalina us. But I'll read it. I'll read this for you all. Is that this was case number 2014021501. This was a business card regarding a business card prepared by an employee of Respondent 1, which is an authorized dealer of Respondent 2, which did not have a correct company name but had Respondent 2's logo. Respondent 2 did not authorize the employee to have the business cards with their logo name. Additionally, Respondent 1 failed to submit an alarm employee registration application for the employee listed on the business card. The violations, as you can see, were below regarding engaging in the business through a name other than the certification name, and that the employees with access all be registered. The complaints were opened against both Respondent 1 and 2 regarding this, and both were issued consent orders. Respondent 1 resolved the matter and settled by consent order and paid a civil penalty of $5,000. Respondent 1 was the one whose employee was using the name of Respondent 2. Respondent 2 was also issued a consent order in an amount of $2,000 for that violation. However, Respondent 2 has contacted us and repeatedly stated that they had no knowledge. It didn't authorize the employee of Respondent 1 to use their logo, and when they learned of using it, Respondent 2 had Respondent 1 immediately destroy those. Given this is why the recommendation is, in light of this information, that this be dismissed against Respondent 2 because they were not responsible for the acts of the employee of Respondent 1 company.
Madam Chairman, I would concur with this recommendation, and I think given the information that the complaint against respondent number 2 should in fact be dismissed.
We have a recommendation by Mr. Roberts to concur with our council's recommendation in this. Do we have a second?
Second.
And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Thank you.
Now I believe we're going to go back to number 11, and I'm going to work with you all to
Before Ms. Brown, are you going to sit in for a little while? I don't know if the board, I think we met you before the meeting, but this is our new litigator. I don't remember who, well, I couldn't remember if it was before the meeting took place or was opened or not.
I'm
But
sorry, I'm one of several litigators, and there's going to be several cases probably that will be coming in the latter part of this year, so I just wanted to also introduce myself as well.
we welcome you. Thank you for coming today.
Okay.
We're going back to number 11.
Number
correct?
11, and I'm
Okay.
gonna start out by saying involves several companies, and I apologize that I can't use a name, but I use Respondent 1, 2, and 3, and then it can get confusing. I try to write this in a way so that it's very straightforward to lay out the facts, but I will work with you, and I will give you all the information that I have in the file, but you may have some questions that I just absolutely cannot answer, but I think we can hopefully get through this. And here we go. This is case number, it's 3 respondents, 2015-0055-911, 2 and 3. Respondent 1 was an alarm company that expired in 2012. Number 2 is unlicensed. 3 is currently a licensed company. This was a consumer complaint that alleged that the respondent company was acting as an alarm company without having a valid license. The complainant alleged that a company purchased the alarm company that she had contracted with, and that this company the new company refused to assist her with concerns involving her alarm system. The complainant alleges her new company never changed the name, and she thinks it has become unlicensed. The respondent company's license had expired in 2012. The original company had expired in 2012. So we did an investigation, and here's what the investigator found. In talking to the owner of basically Company 1, is that Respondent 1's DQA was no longer employed with the company as of mid-2011. The accounts of Respondent 1 were acquired by Respondent 2. Respondent 2 stated that it was formed for the purpose of processing payments of the accounts only, basically for purchasing and processing the payments only. Respondent 2 is not licensed as an alarm systems contractor. Respondent 2 is using an alias name that is similar to the name of Respondent 1. This alias name has the word alarms in their title, like X alarms, but it's not licensed. The individual owners of Respondent 2 also own Respondent 3, which is licensed as an alarm systems contractor and operates outside of Middle Tennessee. The accounts of Respondent 1 are actually in Middle Tennessee. The owners of Respondent 2 and there is a Respondent 4 were previously part of a separate, not listed here, alarm systems contractor and have a non-compete clause with them for the Middle Tennessee area. This appears to be the reason why Respondent 2 is not licensed, because they have a non-compete clause in Middle Tennessee. Respondent 2 claims that it only collects payments on the accounts and states that it is subcontracting the services and accounts to a separate licensed alarm company. It's a subcontractor. The investigator also found that Respondent number 3, which is licensed, is using an alias name on its website that is not a licensed registered name. This alias is to be used as a remarketing of their brand of Respondent 3 in the future. Okay. I'm sorry if that was confusing. And I'll just go ahead and sell my recommendation, then we can make a discussion if need be. Respondent 1. This is the one who actually had sold the accounts. That we don't have any information that shows that they're still continuing to do business after they sold their contracts to Respondent 2. As such, I recommend that it is closed. Respondent 2. This is the respondent who is not licensed, and this is the respondent who purchased the accounts and said all they do is collect payments. However, this is the respondent that sent the letter to the lady talking about the system repair. Is I recommend an authorization of a civil penalty in amount of $5,000 for violation of 304A by holding itself out as engaging in the business as a contractor, alarm system contractor. This company not only purchased the accounts and collects those accounts, but it also used the word, that should not say work, I apologize, it should say word, alarms in its registered trade aid filed with the Secretary of State's office. As such, I don't think that this respondent falls into our exclusion under the rules of .0315 regarding the ability to subcontract out, for somebody to purchase alarms and subcontract out all of those services. Respondent 3, I recommend an authorization of a civil penalty in amount of $1,000 for using this name that we found that's not certified to operate under.
Madam Chairman, I think our council has exceptionally well presented a complex issue. I feel that his recommendations are quite appropriate, and for that reason, make a motion that we concur with the recommendations of council.
I want to ask one. Okay, in your narrative from the investigator's report, the owners of Respondent 2 and Respondent 4, so 4.
4 was mentioned, and it actually is not germane actually to the argument, but to the analysis of this, but they did mention the name of Respondent 4. There is another company that they have that is actually licensed. I believe it operates out of the Middle Tennessee area, which is, it's just kind of free and clear area that's not mentioned here, but we didn't have we didn't see any issues with that company in there, sorry.
All right, we have a motion by Mr. Roberts to concur with our council's recommendation in this matter. Do we have a second?
Second.
Okay, we have a second by Mr. Harvey. All in favor voice by saying aye.
Aye.
All opposed? The motion carries. Thank you for making something very complicated easier to understand.
I appreciate it, and that includes the legal report. And I actually did have Josh Kilgore look at this with me, so.
You had who?
Josh Kilgore look at this with me, so.
Very good.
We bring out the assets and tools that we have.
Very good.
Thank you.
Thank you. Meeting of the Alarm Systems Contractors Board. The next thing on our agenda is the administrative report.
Yes, I believe that's mine, Madam Chair.
Okay.
We're going to go to Exhibit B, which is your open complaint report. On this report, we have a total of 51, and I did not subtract the ones that we have taken care of today. Had the one that was in litigation monitoring, but you have already heard that one from the litigator, and that one's going to be closed. Stop me if you have any questions as we go along. We're going to go now to Exhibit C, which is our disciplinary action report. The month of March, you didn't have any action. April is $5,000. In May, we had $5,500. This what's listed on the internet, and you will see behind that the student loans or the child support suspensions that we also have in your department, in your board, excuse me, if we have any in your section. That is pretty self-explanatory. If you'd like, we'll just move right on to Exhibit D. This is the monthly report. This is the only thing other than minutes that gets faxed to you or emailed to you in advance, so because it's such a big report. But if you will notice, even in this month of April, the alarm board also has had a rulemaking hearing, and they are with the Attorney General's office. From what I understand from legal, they are still there. It's Attorney General's office, and they're released. We're going to get on moving. So if you have any questions on the report, just ask me. We didn't have any issues on any month. The next one is Exhibit E, is the legislative update, which was the sunset hearing that we went to yesterday. I'd like to thank all board members for coming and showing their support, and especially to Mr. Roberts for his helping me with the explanation of false alarms and answered the questions for the senator. We will be getting back with the senator with notification, and there was one other request that they had made, and I will be working on that as well. I've already seen the sunset report. We discussed it, so I'm just going to move on from that one. Have the budget update. This was in your packet with the sunset as well. A couple of questions that were brought up at the sunset, or statements that were made. It was Senator Bell, I believe, is going to try to get a motion passed, a statute that for all of the regulatory boards, that if you serve on the board, if you miss 2 meetings, you will automatically be.
Over half the meetings.
See, he said over half?
Yes.
All right.
Which in our case would
be 2.
Based on past experience, would be more than 2.
Oh, okay. He might have changed that. When I met with him, it was anything. Okay,
So,
that'd be fine.
I think he was saying
He
over
was trying to say-
over half.
Over half. Okay, then
See, and
he'll
if
write
we-
it up, and then the automatic removal. Okay. You also as you said there, you heard them talking about the budget. The boards do try to maintain at least a year's worth. I think from what we see here in the reserve that we have, might be like a year and a half, year and a quarter so far. From last year in the reserves, we do try to keep that enough in case we do need to go into the reserves. But let me tell you again, every July 1, we start all over again. We start with a zero balance, and I must maintain that all the way. Monies we received has got to manage the board. So far as I can tell, we're not having a problem in that area. As far as your reserves, I believe that money's probably going to go to our new computer system. They are going to throw the switch to the new system sometime in September. We will be going dark 2 weeks prior to that. What that simply means is we will be accepting applications in the 11th floor, but there will not be anything inputted into the computer because the old system's being shut off, the new system's being turned on. So technically, we're going to have, as far as I'm concerned, a little backlog of at least 2 weeks. We'll be able to tell we do have your application here, but it will not be processed. It just means it hit the cashier's office and it's sitting on one of our, it'll be on the old system, then they'll swatch it over to the new system. So we got some things going on by the time we have our next board meeting. So if you have any questions, as far as last year, you can see they took $53.86 for core. I do expect that to go up. Other than that, only other thing that we had that I questioned on that, and they did move it from 1314, was training of state employees. That is actually the 1980 from 1314, and 1415 is 1320. That is actually part of my travel for ties that you should not be charged, and they're supposed to be moving that off of that. We do try to watch the budget and make sure every program gets charged properly. That would be going to private protective services. All right, now what we have is Exhibit G. Maximum Security is asking for a third extension. So I'm going to give you a minute there. They asked for the extension in January, and it was granted and expired March the 5th. They asked for the second one on, I think, March the 19th, and it was granted to June the 5th. And they've got a letter also in here to explain why they are asking for the third extension.
The only thing he needs is the exam. It's just a timing issue for him to get.
Take the test. He's got the training, and we're still verifying his experience. He's getting letters from his previous.
She was trying to.
She was
Applied to
gonna
herself,
qualify
and it
herself.
did not.
Okay.
So that stopped it. Started with another one, attempting to be the qualifying agent.
I'd make a motion, we grant maximum security a third extension.
Second.
Okay, we have a motion by Mr. Harvey and a second by Mr. Cockcroft to grant them a third extension. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries.
All right, thank you. We'll now go to Exhibit H, Power Home Technologies. They're requesting their second extension. It expired on June the 29th, or will. They also have a letter asking for the extension.
Their applicant, look.
We're still verifying the experience, and he took the exam and passed it.
Make the motion, we grant Powerhouse Technologies a second extension as well.
Second.
Okay, we have a motion and a second by Mr. Harvey and Mr. Cockcroft to grant this request for a second extension. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, thank you. What we're going to move down now to is our...
Ms. Vest?
Yes, sir.
Were you going to address the issue of the number of meetings we've been holding?
Yes, sir, I was going to do that
At some future
in
point. Okay.
unfinished new
Thank you.
business type. For the appearance, I believe Mr. Nathan Tarrant is here. Sir, I'm gonna ask you to come up here and sit by me for a few minutes, because if he stands up at the podium, there is no mic, if you don't mind. Mr. Tarrant is here for you to review his qualifying agent experience. Now, this is going to take a few minutes, sir, so if you would. He needs to sign in, doesn't
The sheets up
he?
there.
You
on
need
the
to sign
page.
in up there. Let's give the board a few minutes to look over the application, and if they have any questions, they'll ask you, sir.
Looks like most of the relative experience would be what, before Comcast, like you had some alarm experience before that. Were you licensed as a registered employee with any of those companies?
I was supposed to be.
What was the question?
I was asking if he was a registered employee with those companies. They're all Tennessee companies, and I mean that wasn't. Well,
There's information in the back. He was registered with Matrix. Something happened with their company app, and we was registered with Safety.
supporting documentation there for. Did he? We'd like to see that you were registered there, but I don't. That wasn't your responsibility to do that.
Hired on, they were supposed to, register me because I was doing alarm system. Obviously, I had that experience there, but I was doing it.
What all kind of work were you doing there? Or?
I was installing, like with Baker House, I was installing a Demco panels, smoke detectors, pre-wiring homes for that with structured wiring. Even doing sales for the customers with security, putting in cameras as well. And then safety, I was doing the same thing too. Cadix Systems, Dimco.
So are you currently registered, do you hold registered employee classification with the state?
Not right now. He isn't doing this type of work. He owns his for his own company. He was registered, but we could only come up with about 4.5 years based on our records.
You have 4.5 years
Yeah.
of registration. It's just that one of the application, but not registered.
I didn't say that.
Well, he was an applicant where he could work for about 1.5
But he
years.
never got his registration.
I apologize to the board. I didn't think you could work for 30 days without
Right.
making an application. And then you don't work for another 3 years waiting on an application, so I misunderstood the whole thing. I do apologize for that.
So he did not have registration, although he worked that long.
He was registered with Safety for almost 3.5 years. He
That's
was
the
a-
current company, correct? Safety?
No, that's his most recent alarm company. He hadn't done this in a while. He applied with Matrix.
I think we need to let Mr. Turner answer these
That's,
questions.
okay, let me ask. You were employed with Safety until what date?
Until, I think it was 2007. Let me look exactly at the date.
Okay, so from 2007 until 2015, where have you been employed?
I worked at Comcast for 5 years. Then I worked with my father in the family business. I own my own audio-video company, so I do that.
So the family business is not related to this type of industry, okay?
Last experience I had in the alarms was 2007 when I left Safety.
I'm interested, why have you chosen to go back into the alarm business at this point?
I always enjoyed the work. Audio, video was a passion of mine. I enjoyed security. Enough of them. I did, hundreds of security systems, so I enjoyed doing that type of work. And I just add that to my company and get back into that field.
And what is it that your company is doing now?
We do audio, video installation, so it's any speakers, business.
If I understand correctly, you have passed the necessary national training course, and you are looking for the board to accept 5 years of experience in the alarm industry, and that's basically what we come to at this point.
And I believe what we were saying is that we could not document 5 years of experience. That's why we asked the gentleman to come in.
So when you worked for Comcast, I think you said, is that one of the companies where you did installations?
With Comcast?
Yes.
No, I did sales in Comcast.
Okay,
Yeah, it was internet and phone sales. So there was no alarm.
so was it Matrix that you did the system, the alarms installations?
Yeah, I did Baker House, Matrix, and Safety. So that I did security installations for.
That was along with home theater, house-wide audio distribution, satellite cable phone.
Yes, ma'am.
What percentage at Baker House of your time was installing alarm systems?
We installed alarm systems in every house that we did. So, probably about 40% of the time I was doing Ademco installations in these homes. So every house was pre-wired and wired and programmed for security systems. And about the same in matrix and safety systems as well. So that was just part of the standard package that we sold customers. Was security system was just part of it, because we integrated it with the home automation, so they could, with their smartphone or whatever, they can, turn their system on and off. They can arm and disarm it.
Also already taken the qualifying agent test, correct?
Yes.
And
Yeah,
passed.
for so I passed both tests already.
Could I get you to elaborate a little bit more on the alarm systems that you were installing, either for Baker House or Matrix? What all was involved?
Well,
Describe, if maybe you could describe a typical system for me.
Sure. Typical system, we would start at a rough end stage where the house was being built, and we would pre-wire for typically about 4 motions, maybe 2 glass breaks. We'd even do smoke detectors throughout the house, and we'd put 2 keypads, one in the master bedroom, one by the front door, and then we'd put in the Ademco system. I think it was a Vista 16 is what we used, and we trimmed out, we put in all the motion detectors, glass breaks, smokes, and programmed it via keypad, and tested the system, tested the smoke detectors, make sure everything, worked correctly.
Who actually did the programming on those systems?
I did. I did, and another gentleman, so there was 2 of us in the company that did it. And then the same with Matrix. We would do Ademco, DSC, and CADX installations, and we would do the same thing on a rough end. We even retrofitted some houses for security or put in wireless systems. There were several log cabins that we did a CADX wireless system with a NX8 V2 panel and a wireless system where they can arm and disarm via key fob.
And were you involved with programming all of those panels?
Yes. Yeah. Yeah, with the CADX, we programmed with a DL900 program from the computer. So we didn't do that via keypad, we did it via computer. And that was the same with the safety systems. Safety, we did primarily all CADX installation there as well, using the DL900 program for it.
All your information, you weren't on the job site working out kinks when it didn't work correctly the first time?
Oh yeah, we were on the job site, because if it didn't work, once we dropped the program to it, if it didn't work, then we'd have to troubleshoot why the contact sensor wasn't working or why the smoke detector system wasn't working.
Only then were you dispatched to the job site?
No, we were on the job site from beginning to end, from programming, because what we did was we programmed there on site and dropped the program to the panel, and then we had to test it, make sure all the doors had continuity, made sure the smoke detectors worked, make sure the glass breaks and motions were picking up correctly, and test them with acoustic sensors. So, you know, we could only leave the job once it was done and show the customer how to use it.
Cadex, the last brand name that you worked with,
Yes. Yes, Cadex.
the most recent.
Mm-hmm.
Madam Chairman, it would appear to me that this that Mr. Tarrant meets the requirements of according to our statute. He seems to have been directly involved with the installation and programming of alarm systems. Even though he's been a bit out of the industry for a few years, it looks like to me that he meets our basic requirements. So therefore, I'd make a recommendation or make a motion that we grant, we recognize the experience that he has had, and that his license as qualifying agent be approved.
And I'll second the motion.
Okay, we have a motion by Mr. Roberts and second by Mr. Cockcroft to grant this applicant his qualifying agent license. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Congratulations.
All right, thank you. We're going to go now to our alarm employee appearances. Michael Brian Jeffries. We have Mr. Jeffries here. This, I don't know how to pronounce it. Up here and sit by me. Your QA's with you? Yes, ma'am. You want to?
Excuse me.
This is going to be Exhibit
A.
K. You reviewed this gentleman's record at the last board meeting, and you did.
I think some of our main concern was just the most recent. We kind of wanted to hear just, from your, straight from your mouth. We've got some of your explanations here, but some of the more recent ones we were concerned about, if you could just kind of tell us what happened and maybe what's changed and.
Which ones in specific?
The 2009 and 2013. The 2013 what was a traffic stop, I think.
Was that the possession one?
Yes.
Right.
Okay. Yeah, I made an illegal turn, and there were police officers on that intersection, so I was pulled over. I had a passenger with me. They searched my car and took my information down, and they found controlled substance in my vehicle.
What happened in court on these charges?
In court, I was given fines and had to do 5 days community service.
On the possession charge?
Yes, it was
What was it? Was it marijuana or cocaine or what?
cocaine.
About that 2009 larceny and theft, what was going on with that?
Thank you. Well, at that time, I wasn't doing too good. I was out of work. I was working for the electrical union. I was laid off. My unemployment ran out, and couldn't find any work. I was desperate to survive, so I shoplifted so I could have some food, and I was caught shoplifting, and I was given community service for that also, plus fines. And it was just a bad time in my life, and I'm very regretful of it and ashamed of it, but that's what happened.
On one of your papers, it's got, this was also from New York, harassment, endanger welfare of the child, and petty larceny.
That was the same type of thing, and I had my stepson in a car with me. So the endangerment was that I left him unattended in the car.
Also shoplifting in this incident also?
Yes.
What was the harassment?
I don't know what that was.
Okay.
Madam Chairman, I wonder if the company representative here would have any comments that might add to our deliberation.
I was trying to find the gentleman's name. It's what, sir? Do they need to sign in also? I knew it was referenced, yeah, Jewel Hill. I knew your name was in a letter, but I couldn't remember when I read.
My partner's name is Randy Mann. He is the actual company. Chris has been a very valuable employee of ours since December of 2014. Bad parts of his life prior to. We do a pre-drug testing. So he passed the drug test. We do random drug testing. We're part of the Tennessee Drug-Free Workplace. He has come in and proven himself to be a very valuable employee. He does exclusively commercial fire installs, so he's not doing residential. He's not doing intrusion. It's strictly conduit and worlds of wire. And his supervisor, I'm standing up here vouching for him. He's made some mistakes, more than some and less than others. And I'm standing here before y'all asking if y'all to give him a chance. I believe he's turned his life around. And that's as much, I'll share more. I've got 39 years, and some of y'all know me for a lot of years, and I think he's a stand-up man now. So.
Do y'all have questions for Mr. Hill?
Basically, I guess it comes down to, would you have him installing an alarm in your house? I
would, yes, sir. Knowing him, I would. And I'm one that's looks at this law very seriously, and I'm a component of it, for it, was for it from the very beginning. But I believe there are people that make mistakes, and I'm one that tries to believe the best in people. And I've made mistakes myself. So, but yes, sir, I'd have him in my home or my mother's house or sister comfortably.
Because that is, that is what we feel a very important part of the law. That is our biggest concern. But it does speak a lot that you come to vouch for
Wouldn't
him.
be here if I didn't believe he's got his life together.
Or you feel like you have your life together now?
I moved
No
down-
domestic problems or anything? You've got all that behind you?
It's all behind me. I moved from New York into, I live in Oak Grove, Kentucky. My lease is up in September, and I'm looking to move into Tennessee. I'm engaged now, getting married soon, and I love it out here.
Questions?
Madam Chairman, I make a motion that we grant Mr. Caramu's registration as a registered employee.
Okay.
Second.
We have a motion by Mr. Roberts and a second by Mr. Cockcroft to grant this gentleman his employee registration. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations. Thank you, sir. I think Dwayne Peters is next on the agenda. No?
We can probably go back to the first one if Mr. Jeffries is here. Mr. Jeffries, won't you come up here, both you gentlemen, and sign in? And then you can, Mr. Jeffries, you can have a seat by me, and you could have a seat in case they have a couple of questions for you.
What is your name, sir? No. Charles Murdoch. Okay.
This document's for you, so you'll know exactly what they're looking at. If you give the board a few minutes to review it.
following this that the record doesn't show some of the more, there's some things that were disclosed that are more recent, but the record's not showing those? There's stuff that's on the,
Are you talking about the one from Supreme Court of California? County of San Francisco? The one you're talking about?
I just see several notes that are more like, because the
Personal notes?
criminal record looks like it goes to 2000. Right, all these other.
Okay. I see now.
Talking about on his application itself, Scott?
The
Shelby
backup
County.
document.
Report.
I believe if you do look at or this is another individual that you've already seen their record and you've asked for his appearance.
Is it Power Techniques, whatever? Power. Are they registered in Tennessee? We're lacking some numbers is the reason I was asking.
Mr. Jeffries, you have quite an interesting record here. Would you care to make some sort of a comment or statement that would help the board in its deliberation?
Yes, sir. When I was living in California, I had gotten off into some serious substance abuse, and after that, about 3 years of that, living like that and living on the streets, I decided to move back to Tennessee, where I'm originally from.
some of these charges are domestic. A lot of these charges that from in Tennessee are domestic in nature. A lot of them are a result of a ex-girlfriend of mine. There was a long-term relationship. She had 4 kids that her and I tried to raise 2 of them together, and she got off into drinking very heavily and made some false accusations. That would be the aggravated assault charge, which was that was a total fabrication, which never happened. As the kids got older, they got kind of really out of control, because they didn't see me as a father figure, so they really were starting to get into trouble a lot. And one night that I was over there, we were in the bedroom, we were talking. She was drinking very heavily, and which we had lived together before that for about 7 years, and but I was over visiting her, and we got into an argument. I don't remember what it was about, but it was probably about something about her, being so intoxicated. But anyway, her son came in, the oldest son came in, and tried to take up for his mother, which he's trying to intervene into the argument and getting in the middle of it. And at that time, he decided to try to charge me, and like he was going to attack me, which the guy was, he was bigger than I was by 20 pounds. So I decided to push him to the wall, and as I exited the house and left the scene, so just getting myself out of there, basically, to end the argument and to keep anything from happening. They called the police after I left, and but I called her the next morning, and she said that the police wanted to talk to me, and so I went back over to her house, and they arrested me and for the assault, which I'd pushed him against the wall. And we've ended that relationship. It's been over 10 years ago, and I haven't had any problems with her, and I haven't seen or heard from her in about as long, about 10 years. And now I'm pretty much, I've cleaned myself up. I don't drink, I don't do drugs, and I go to Celebrate Recovery occasionally. I was told by the court to go through anger management, which I completed that. And during that year, we also at the first of that year, she came over to visit me, and she had a blank prescription form, which she had filled out for some pain medicine, and signed it. And she had been drinking that night, and I had been drinking, but not quite as much as she had. So I drove up there to Walgreens, and she presented it to them and wanted to get it filled. And we were told to come back in an hour, and when we came back, the police were there. They had recognized that it was a falsification. And so since we've broken up, I haven't had any problems with the law or anything at all, and just pretty much kept my nose clean, and I've been doing alarm systems for about 20 years now, and I really enjoy it. So I choose to stay in it. And And as much as I can say about it, all is
Your last arrest was, I think in '06, is that correct?
yes, ma'am.
What is it that you do in the alarm installations? What is your role?
Install security systems. I've also been in sales. I've sold systems and turned right around and installed them the same day. Played that role, and I was operations manager for Secure One ADT for almost 2 years. That was forgive me for not remembering the dates, but I did do the operations manager for a couple of years and went back into. I've done also some little cable work and a little satellite work, along the way. When times got slow with the alarm business, but
Is this in Tennessee or Mississippi?
in Tennessee, and
Have you ever-
Tennessee, Mississippi, and Arkansas.
But has he ever been registered before?
Yes, I have had a license in Tennessee. Yes, ma'am.
Registered, excuse me, a registered employee license in the
Yes, ma'am.
past with Tennessee?
Yes, ma'am.
Okay.
Who was he registered with, Beth?
Superior Technologies, which was in Mississippi, but it was under Tennessee's license.
A record of it if you had a registration. Been working in it about 20 years.
Yes, ma'am. Exactly 20 years.
Did did your registered employee license expire? They just weren't renewed, or you got out of the business? What was the reason that?
I had work for Secure One, and after several requests to the ownership, to just get it transferred over into their business, under their business, they failed to do so, and I guess it was 3 months after the last time that I actually, called up to Nashville to request them to transfer it over. The company filed bankruptcy. I was given the choice they split up into two companies. I was given the choice I was a free agent. I was able to stay with Secure One, which I'd been with them in Memphis since day one. So I decided to stay with that company, but they gave me the choice to either become operations manager with the new company or stay with Secure One, and turns out both of the companies actually filed bankruptcy within 6 months after declaring bankruptcy.
Okay. He applied in 2000. Thousand and one. What company was that with? Do you remember?
Superior Technology.
George Fox was here with him at that time. In 07, but that was denied. Let me see why. I think it. In Memphis, he applied, that app was closed. Secure One. Alert, 1999. Again, these were thousand, and then these other charges, some have occurred since.
He came back in 2007 and applied, and it was denied.
I don't think it was denied. It looks like it was closed. Well, they attempted to transfer him, and he wasn't eligible because it had been over 90 days. All this other stuff over to this new record, so it's all in one place.
Y'all have any more questions for?
Hear from the QA.
That's what I was getting ready to do, is ask the QA to come forward. If we didn't have questions for him. I know I've already tried to tell him.
I've actually known Brian for about 19 years. We worked together at Security.
If you don't mind, I know that's convenient, but unfortunately, the microphone's not in a convenient location.
I've actually known Brian for about 19 years. We worked together at Security Alert. I knew him to be a competent and talented technician at that time. Once I left the employ of Security Alert, I didn't see Brian again for several years. He was referred to me last year. Said he needed some work. I've always known him as a good guy. He did tell me that he did have some blemishes on his record. And, you know, I said, well, we'll work through it. He's been very valuable with us. Kept business rolling when we needed help. I don't have enough work to work him full time, but he's always eager. He's always on time. He keeps a good attitude, and you know, I trust him. He comes to my house, hangs out every now and then. So, you know,
What are his typical duties with you when you do have him working?
We work on a lot of multifamily properties, and we just go out as a crew. There's usually 2, maybe 3 of us going out, and we work alongside each other with that. He also does some, you know, single resident as well. He's done some light commercial, like office type establishments. You know, I could have just as easily, you know, terminated him, you know, when he came back the first time with the cease and desist. But like I said, I've known him. He's a good guy, and I wanted to kind of give him a chance. So.
Questions?
Madam Chairman, I make a motion that we grant Mr. Jeffrey's application as a registered employee.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to grant this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations, and thank you for coming. Thank you. They need to update their stationery.
Yes, we did see that there is a,
Hey,
they,
Chuck, you didn't put your company certification number on that letter.
we will be filing a
We
complaint for that.
probably will send you a letter.
Oh, what now?
This letter you sent in?
You have to have your business, you have to have your company license number on
hiding
all
somewhere?
letters, all correspondence.
Also, his QA's missing too, his QA license number.
Okay.
It's on my contracts, I promise.
Okay. Thank you.
All right, thank you. Do we have Mr. Peters here? Do you have your qualifying agent with you? Would you both please sign in first for me? All right, Mr. Peters, what you have in front of you is the same documents that the board has. So please give them a few minutes to review it. Mr. Peters is also here because you requested him from your last meeting.
On the application are the same thing, right? It's the charge and then the disposition on the 09 and 10.
It's worded on the app.
So you're currently on probation until 2020, is that correct?
Mr. Peters, would you care to make any sort of a statement that would help the board in its deliberations this morning?
Basically, I could say, since my last incident, I've, been heavily active in church. I have obtained my electrical engineering degree from ITT. I purchased a house. I'm basically, try to be a role model for my daughter, 7-year-old daughter. Was not, and just trying to, have a career in the electrical field, whether it's alarms or technology.
What is it that you do with ADT?
Install alarm system, cameras, basically, burglar alarms, access control, programming, installation.
Are you located here in Nashville?
Yes, and
Okay.
Tennessee.
How long have you been working for ADT?
About 7 months from October of 2014.
He had a previous application on file when he was hired in October, and it was closed because he didn't send the court records.
Questions for him?
I don't think so.
Who is your, come forward, yes.
Yeah, Dwayne has been an exemplary employee.
Would you introduce yourself, please?
I'm sorry?
Would you introduce yourself to the board, please?
Charlie Warren, I'm the qualifying agent.
Okay.
Yeah. Anyway, he is reported to our team, been an exemplary employee. We sometimes have fairly extensive procedures for operations and safety, and he's complied with all of those. He has a perfect attendance record, has volunteered consistently for late customers in need, late installs, and volunteered on his days off. He's been very responsible. And I think probably more than I can say anything else are the number of customer accommodations I received on him, which exceed the number that I've received from any other of my 38 technicians over the past 6 months. So the board'd like to take a look. They're actually nice, very nicely done, and speaks of his customer service responsibility.
Do you have any drug screening policies with your business?
Yes, we do. We don't do random, we do with the incident, whether it's a
We see some other, possession charges, but what really concerns me, and I think some of the board, is that it is a felony possession, and they were showing intent to distribute, I guess, based on the quantity. Tell us what happened, or what, elaborate how things changed, and.
It was a routine traffic stop. I had 2 ounces of marijuana on me. At the time, I was really bad influenced. As as a kid, I was like 23, just coming from the Virgin Islands or what's not. Since then, I changed my lifestyle. I have found new company. As I said, I go to church. I kind of distance myself from a lot of old friends. Pretty much, it's really behind me. Since then, I went to school. I try to talk to my daughter because, she really watches me from day to day. So I try to, stay, really pretty much a role model for her. So it's nothing that I want to get back into, because it's real dark part of my life that I really regret. But since then it's been on the up. So
I don't know how the quantities or whatever relate. Is that something that's really close to, that made it a felony or made it possession?
I can't speak to that. It was Georgia, so I really.
You know what?
I know it was the Lookout Mountain Judicial Task Force that got him, so it was enough to trigger a felony amount. And that's got to be significant with marijuana.
I often think it, but I don't always say it. I guess it's probably the second time I've ever asked this question. You write a letter saying that you acknowledge that you reviewed the charges in court dispositions of this employee. So many times I see QAs appear for their employees, and they're like, oh, gosh, I got to go to Nashville. I got to sit through that meeting. It's really not just sitting through the meeting. You're saying you're willing to put your license on the line for this individual. You feel like you know him that well, and he's turned his life around. And if something happened, you could lose your license.
Absolutely. I take it very seriously. And Wayne, as far as in his day-to-day operations since then.
Where do we stand from a legal standpoint with, because you're still under probation, right? Or
5 more years. How many more years?
stepped out, but as far as our
Got 5
attorney
more
here.
years?
Is there, Miss Ashley, are there any legal implications for him being on probation for this felony drug offense for 5 more years? Okay.
Well, Vivian, can you tell us is it a misdemeanor or a felony? It says on the paperwork it's a felony?
They charged him with a felony, but
They reduced
I think they reduced
In the application here, it says reduce, First Offender Act reduced to misdemeanor.
Yeah, reduced to a misdemeanor.
have
It's just
it
that he's on
reduced?
probation. There's always the possibility of putting the gentleman on probation and doing the drug screenings as we have in the past. You can put it on for a renewal period, or you can put it on for the entire 5 years that he's still on probation.
I must confess, from my looking at this particular record, I am somewhat surprised by by 10-year probation. That is somewhat surprising to me. I recognize the offense was reduced to a misdemeanor, but the length of the probation just seems to be unusually long. That would lead me to expect that the amount of the marijuana involved was very substantial, or there was some sort of extenuating circumstances, and that's just an unanswered question in my mind. Can you share any information that would shed some light on that?
I'm just as surprised as you when it charged me. I guess it was just the county of their law. It was in Georgia, Cotusse County, a real small town. I right now I'm trying to motion to kind of get it expunged or get it retried. As we speak right now, I'm actually trying to work on getting it expunged right now. So it was only 2 ounces. I guess that's their law or whatever. Cause when they told me 10 years, I was like full 2 ounces. It was real crazy. And
What were the circumstances? I mean, tell us briefly what happened when you were arrested. What were the circumstances?
I got pulled over.
Were you by yourself?
Yeah, I was by myself. I guess I don't want to say anything. It was just like he smelled it on me. I wasn't hiding it, and I told him I had it, and then he said over an ounce is a felony in Cotusse County or what's not, and I had bond. Then I had to go back to court, every few months or what's not to get it, looked at, and that's the result of it. 10 years probation, and I was, I couldn't.
Were you delivering that marijuana to sell?
Nah, it was just in 2 bags, and it was
It on you, and then he pulled you over.
No, he pulled me over, and
The first comment was that it was a routine traffic stop.
it was a traffic stop. He pulled me over on the interstate, and
For what reason?
I have no idea. It was during the day, 1 o'clock during the day. He pulled me over. I guess he said I was
Know a lot about the law, but don't you usually have to have a reason, or an initial reason? Tell light.
That's what I said. I mean, I told my lawyer the same thing, but that was the result of it.
Did you just get to the States from the Virgin Islands?
I was here in 06. It was 09, probably 3 years. I've been here about 3 years prior, so.
I'm just going to ask you straight out, were you transporting drugs on a regular basis, or was that the first time you had done that?
It was, I have, I've been to Georgia because I have family in Georgia and what's not, and it was just me coming back home that day. And I never, it wasn't a routine for me like every 2-3 days or something like that. It was.
But you had done that before?
I was employed. I was working construction at the time,
We're working where?
Construction. So I always had a job, so it was not like, as I said, it wasn't like my income. You know what I'm saying? It was not me, working for somebody.
Were you just smoking it? I think what she's asking, you just smoke it, or were you selling it?
Yeah.
Well, that's pretty, it's either yes or no.
Yes.
Yes or no, it's a either or.
Yeah,
He was
okay,
smoking
yes.
it or he was selling it. It's not,
Gotta
or
be yes
yes
to or no to
both.
one of them.
Yes.
Well, I, for one, would be a little bit more comfortable in granting this registration if I felt like there was some sort of a drug testing program. I'm sympathetic to Mr. Peters. The testimonies indicate that he has tried to turn his life around to better himself, to be an example for his daughter. The recommendation that you as an employer have presented, the comments from customers, all are significant in my mind. I, for one, would be a lot more comfortable if there were some sort of a drug testing program that Mr. Peters was involved with, to let us be assured that drug usage has ceased. And it's my understanding, or I would assume from what you've seen, that that's the case.
I would say through probation, they had me go through rehab and counseling and what's not. Since then, I've been clean since 2010. I've never really touched it. I have family members, and I just walk the other way. I mean, I'm really, really strict about it because it's my career, and especially as I said, I can't really stress that my daughter actually watches me every move I make. So.
Well, it sounds like you're making some wise decisions.
Yeah.
Let me ask you, as part of your probation program, is there any sort of drug testing involved with
yes,
that?
I have to take one actually Monday. So,
How often do you take these tests?
I think twice, just randomly. It's randomly, so it's not like it's scheduled. They'll call me. I'm on unsupervised minimum probation, so I don't report every month. It's a house visit. She come in my home, sit down, ask me if I'm employed. So it's not really like I'm going in reporting every month. So they'll call me, I'll call in, fill out a form. It'll be like last year was like four times. This year I had 2 this year already, and then this will be the 3rd one. So it's
I don't know. We'd ask
Him to forward
legal
us
this
the
question.
results or something.
Or for the qualifying agent to supervise the.
Probation transferred up here, so he's being handled through the state.
You do have your probation transferred to Tennessee? Okay.
If he was to violate his probation, he'd be rearrested, wouldn't he? All right, why don't we do this? Why don't again, I'm sympathetic to Mr. Peters to try and improve his life and that of his family. If he were to be rearrested, could we have some assurance from the company that we would be notified of that? Because you would certainly become aware of it quite quickly if he were rearrested in violation of his probation. That would seem to me to be a reasonable measure on part of the board to have some assurance that things are proceeding in an appropriate fashion.
Our HR department would require we terminate him if that were the case.
Okay. Well, with that, I'll make a motion that we grant Mr. Peters' application as a registered employee.
Okay, we have a motion by Mr. Roberts to grant Mr. Peter his employee registration application. Do we have a second?
Second.
And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
Aye. All opposed? Congratulations. Yeah, he's missing a number two.
Why are we
Does
saying he
have
has
his
to have a
license
QA?
number.
It's the company number.
Yeah, he
that
didn't
has
have to have a
be
QA number.
Oh, I thought he had to include it on there also.
All right. Next on the agenda is law employee applications review, and I believe we got like 18 of them.
Okay, we're going to call back to order this Thursday, June the 18th, 2015 meeting of the Alarm Systems Contractors Board. I think the next thing on our agenda will be Exhibit M, Alarm Employee Application Review.
Yes, the next thing you have is the 18 18 employee applications to go through. Start with M1. If it's in the same order that I have, Beth has prepared the first sheet, tells you of the charge and conviction. Then you will have a copy of the application, page 3, Then you do have the explanation written there, and then the court documents. And,
So we're looking at M1 first?
yeah, M1, he was denied, this individual was denied material misstatement the first time, so this is a reapply. Isn't it?
Yep.
Won't they all reapply? And we have a letter from the qualifying agent as well. This one.
Are these lights on a separate switch? These can lights? They glare right
Probably
down.
over there.
Yeah, there's two.
See if you can just cut those off.
Probably that second.
Yeah, there's none over.
Oh, try it.
That more better?
Yeah, that turned.
That is more better.
The other one did more better.
Yeah, you can cut them both off if you want, I guess. Yeah.
I don't
You
know
gotta
if the
operate in.
screen looks awful dark.
Huh? Are we showing up with that light off?
Well, it's back on.
That one.
Can light, the can
do-
lights
can
are
light
always
is-
a glare problem.
It's
These are-
reflecting on the iPads and it makes it almost impossible
These
to read them.
diverse lights are a little easier to deal with.
Mm-hmm.
Well, they ought to approve.
Decide to quit, it's gonna restart itself.
Mr. Anderson his employee registration due to 3 accounts of shoplifting in the last 8 years.
Second.
And I think that might help if you actually name.
We have a did you second that?
Yes, I did.
We have a motion by Mr. Harvey and a second by Mr. Roberts to deny this registered employee application on poor moral character based on 3 shoplifting charges within the last 8 years. Convictions, I'm sorry, convictions. All in favor, voice by saying aye. Aye. All opposed? It's denied.
All right, we'll go to the next one. It's going to be M2. You have the description as on the first page. Excuse me. And you have the copy of the application, which is page 3, that does list the charges. You have a letter from the company. No, that's his letter from him, looks like. Some court documents. That's it.
Paperwork in here on the Gallatin.
No, there's a note there. He didn't give us the next one. On TBL report confirms that he had probation for a year. I just don't have any.
Madam Chairman, I make a motion that we grant this application for registered employee.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to grant this employee registration. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
The next exhibit is M3. All the charges or convictions. Copy of page 3. 2 copies of page 3.
There's two things.
Document in the back, or sheet, I should say. That
I think that's all.
we don't have any paperwork on the aggravated burglary. Looks like it was in Florida. No court records, whatever for that. 98 court.
I'm sorry. I think that was aggravated battery. Sorry.
What'd I say?
Burglary.
Oh, did I? I'm
I was thinking
sorry.
I missed something there. I was looking back through
I'm
where
glad you
was
caught
that?
my- I apologize for that. Where is it?
Not enough information on, really.
This is all the information we've got?
3 pages?
All they sent, and I've asked their compliance people to send what they're supposed to do.
Make a motion that we send this one back and ask for more info.
Second.
Motion by Mr. Harvey and a second by Mr. Roberts to request more information. No action taken on it today. All in favor, voice by saying aye.
Aye.
All opposed? This one's going back.
All right. If you would, please turn to M4. Page 3. Now, we do have a letter from the company. Court documents.
Motion we accept Mr. Bolton's employee registration.
Second.
Okay, where's
Motion by Mr. Harvey and a second by Mr. Cockcroft to accept this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion passes.
Next one is M5 with the written explanation. Page 3, there are several sheets here of written explanations and some documents. Company as well.
Every time he spells that. But see, it says
Goodness, excuse me.
Motion to accept Mr. Cameron's employee registration.
We have a motion by Mr. Harvey. Do we have a second?
Second.
And a second by Mr. Cockcroft. To all in favor, voice by saying aye.
Aye.
All opposed? It's approved. It passed.
Okay, let's go to M6. All of these are in the same order. See his written explanation in the affidavit of complaint. Also see a document in there that you would not be paying any attention to. It should not be included in the packet.
Which one is it?
It's the expungement. I just don't think they ought to see this kind of stuff.
Madam Chairman, I make a motion that we grant this application for registration.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to accept this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Now we're going to go to M7.
Lindsay Davis, I must, since she is an employee, I should recluse myself from discussion on this. There is a letter that I wrote that sort of explains the circumstances. I would be glad to answer any questions if there were any.
Original sheet, it says this happened in 2012, but in your letter it says 2008. I'm just curious.
Yeah, the 2008, she was charged with failure to appear to prosecute.
Madam Chair, we can't hear you.
I'm sorry. The 2008 was a failure to appear to testify against an ex.
I guess I'm not. I hadn't
There's nothing in there.
explanation for that one yet.
There's not an explanation for the 2012.
Altogether.
Does mention both in her letter. She just doesn't say a whole lot about the 2012.
I'll make a motion that we accept Ms. Davis' application. Recommendation by her QA.
We have a motion by Mr. Harvey to accept this employee registration application. Do we have a second?
A second.
And a second by Ms. Jones. All in favor, voice by saying aye. Aye. All opposed? And you did note on there that Ken recused himself, correct? Okay. All right, number 8.
Madam Chairman, may I ask just, the board's already taken an action. Miss Davis here quit us abruptly back when she and her boyfriend were having disputes and such. At that time, she was far less mature than she is today. Since she has come back to work for us, she has been an absolutely exemplary employee. She is just like two different people from what she was some years ago. I thank the board for their consideration, but you've made a wise choice.
Thank you.
M8. Rather thick. It's going to take a little while to go through it.
Product, equipment, possession, the same thing as paraphernalia.
Technology difference.
That's his terminology.
I know.
We were just talking about, we actually were talking about that yesterday. There's several more of those in here.
Everybody's got it. Make a motion to deny Mr. England's employee registration due to lengthy current criminal history, and the fact that there's no letter in there from a QA even asking for him to have a job. So that would be my recommendation.
Okay. We have a motion by Mr. Harvey and a second by Mr. Cockcroft to deny this employee registration application based on a lengthy and current criminal history. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Okay, we'll go to M9.
No, he's field representative. He's one of these out-of-state companies that send people in here and knock on doors.
Okay.
We don't have any letter of explanation or recommendation from the QA or anything, do we? Madam Chairman, I make a motion that we reject this application for registered employee.
Okay, we have a motion from Mr. Roberts to deny this registered employee application. Do we have a second?
What reason?
Lack of information. Have a second? Huh? Yes, ma'am. Yes, that's correct.
I'll second.
And a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, now we're at 10.
Roland, his QA.
Yes.
Also, doesn't sound like that it's his license that could be lost and not.
So that makes this applicant above average.
This one's,
Mine's at 38% now.
mine just actually cut off.
You can look at mine too. I'll get you another one. That's in. Oh.
Let's see. I left them plugged in.
Leave them up there, Cindy. Somebody else might need one.
Let's see.
Madam Chairman, I am not comfortable at all with this application for registered employee. Mr. Glenn, he has just an extensive list of various law violations, of some of which are relatively recent. We do not have we have an acknowledgement from the QA, not any sort of a letter of recommendation. I could not grant this application given just the information presented here and the lack of a recommendation from the qualified agent. If the qualifying agent would choose to appear and make a positive recommendation on Mr. Glenn's part, why, I could perhaps reconsider, but given the information we have at this point, I could not make a motion that we grant this application.
I'll second.
Okay, we have a,
He wasn't done.
I'm sorry.
I'm just trying to really think the best way to make that into a motion. Let me put this in a motion that unless we get a positive recommendation from the qualified agent concerning Mr. Glenn, at which time within the next 30 days, under those circumstances, I would be willing to reconsider Mr. Glenn's application, absent the letter of positive recommendation from the qualified agent. I would want to make a motion that this application for registered employee be rejected, not granted, denied, based on poor moral character. If we get a positive letter, then you can bring it back to the board.
Okay. We have a motion by Mr. Roberts and a second by Ms. Jones Mr. Harvey with deny unless there is, for poor moral character, unless there's a letter of positive comment. However you want to
Positive
post it.
recommendation on
From
behalf
the-
of the qualified agent within the next 30 days.
All in favor, voice by saying aye. Aye. All opposed? It's denied. 11.
I got a question about that, kind of, or a comment really. His QA is in Utah. But though they're applying for a Tennessee license, I'm assuming for him to come sell in Tennessee.
You said they're those drop, where they drop them into the community.
Very aware of them. I just wondering who.
Overseas operations
Yeah,
here in
I mean, who
Tennessee.
is- who-
They don't have an
Here,
office.
they
They don't
so-
have to have an office here. They just send these people in buses.
Some of it may be over by the time this is dealt with, I guess.
By the time we deny it, they probably have already finished their summer sales and they're gone.
Now, the farther away that you are from Tennessee, the better off you are. Joe Blow here in the middle of Nashville is going to get a steeper fine and be watched closer than these other states.
I think we can move on to M11.
I don't have a letter from his QA either.
I just don't believe there's anything in statute that says they have to provide one either.
No.
You referring to a recommendation to you? Yeah, I understand.
They don't, no, they're not required to, but it most likely would be denied without it, so
Well, the
it would help on the.
instruction applications tell them to mark yes to any of the following questions. You are required to provide this office no later than 30 days after the completion of this application. Certified copy of the warrant or other certified court documents showing the final disposition of your court that deal with the charges no longer has these records on file. You must obtain a certified letter from the court clerk to that effect. Complete explanation of the factual circumstances surrounding each charge should also be provided. Failure to fully disclose all arrest information could disqualify you under 6232-307.
Yeah, that's the end.
Motion to accept Mr. Hagan's employee registration.
Second.
Okay, we have a motion by Mr. Harvey and a second by Mr. Roberts and Ms. Jones to accept this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Thank you. We can go to M12. We do have a list of charges with this one as well. Copy of the application. We do have a letter. Did you get a written explanation? We have a letter from the company. Didn't it say it on all correspondence? Does it have to be from the QA, or is it just the company?
Motion we accept Mr. Hayden's employee registration.
Okay, we have a motion by Mr. Harvey to grant this employee registration application. Do we have a second?
Second.
We have a second. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, move on to M13. Have their own written explanation, several of them. Material misstatement, this is a reapply. Mm-hmm.
All this information, I think I need to recuse myself from this one.
No, the application's not.
What wasn't disclosed the first time? Was the trespass or the?
I think he checked no the first time, but I can look. Look, oh, look.
I'm not as concerned about the trespass as the.
Then if you look at that burglary was amended down to criminal trespassing, which is going to be a misdemeanor. It went from a
That we denied April the 1st. He didn't put it all he said was criminal trespassing. No date, no court records, and no explanations. Florida charge or the other stuff. I think
Madam Chairman, I make a motion that we grant this application.
Okay, we have a motion by Mr. Roberts to grant this employee registration application.
I second.
And a second by Ms. Jones. Mr. Harvey has recused himself. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
right on. We'll just move straight on to M14. Have a lengthy explanation from the individual. Court documents. I don't see anything else.
Make a motion to accept Mr. Marks' employee registration to open this up for discussion as much as anything.
We have a motion by Mr. Harvey to accept this application and open for discussion. He said he didn't have the money to pursue it.
However, he's on probation for 18 months, which would be
Registered gun.
Registered, you said, yeah.
As far as that he did not qualify for public defender. Something is that done. I wondered when he was saying he couldn't afford to continue that, but he would have lost on his own.
Let's see, we've got a motion to grant the application, isn't that correct?
Yeah.
Was there a second to that motion? I'll second that motion.
Okay. We had the motion by Mr. Harvey, a second by Mr. Roberts to grant this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Here's number M15. Bit different from the rest of them. You do have a letter from the company. No. It's on company letterhead. Yeah.
What is the deferred adjudication? Is that like a pretrial diversion?
Say it's probably similar to it.
It's similar to it. It's
I've just never heard that particular phrase or term before.
generally under a different provision. It's a similar type thing. It's similar type. I don't know all of the. I can find out more about it for you, but it's really a specific nuance of criminal law. But it's under the similar realms as to that. I don't believe it. I don't believe that will allow for an expungement when it's done.
And years probation.
It's not 10 years probation though, is it? Because it's,
That's what it says in
He
his
had
letter.
completed it.
Probation is 500 hours of community service.
He completed it. There's a letter in here. It's
well,
completed it.
I was wondering why it shows it was completed in 98 if,
It says, I petitioned the judge for an early release from the
Okay.
probation.
okay.
And I was granted the early release in October of 1998, so that corresponds with something else you found, doesn't it?
I hadn't read his letter yet. I was still looking at some of the other.
Gives him a lot of time to think, doesn't it?
Crashing 500 hours.
Actually, that last letter in there is his letter to the judge, asking him to release him from probation.
And obviously the judge felt like there was
Right.
something to have granted the, right. I'll make a motion to approve,
Second.
Okay, we have a motion by Mr. Cockcroft and a second by Mr. Roberts to approve this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed?
Would I
The
be,
motion carries.
would I be correct in understanding that Red Hawk Fire and Security Monitoring LLC is the company that this applicant is working for?
It's their central station in Texas.
Hmm. Registered, is that a company registered in Tennessee? I wouldn't have guessed it from their certificate, from their certificate number on the letterhead here. Don't you see it missing right up here at the top?
That's what I
I
was
thought
saying.
that's
We don't
what you were
see
making
it.
fun of, but I thought, well, maybe it's a real low number. So I went back to look.
It'll be real high.
Or be not at all.
That's possible.
Is there any green?
Picked up their letterhead. That's the one we had a while ago. Somebody else picked it up.
About the
Just
fourth
he
document.
Yeah, he wrote it on their
He
letterhead.
wrote it on their letterhead.
Well, I think it's a separate issue that the staff might want to investigate further.
They need to have
Well,
probably
they're
the
in
number.
Texas,
Well,
you know?
in Texas, they still put Tennessee number on it.
Well, like most of these companies, the QA types it in there because they know it's required.
I understand.
Okay, we're going to, I think, M16 now.
That is correct.
What I thought.
Bought this one because it's a pretty current charge.
This is really an interesting document. The General Sessions Court of Washington County, Tennessee, sets the court date almost a year before the offense.
Right.
That's pretty cool. I've never seen that done before. The court date set up towards the top of the document is 9/3/2013.
It was actually September 2nd, 2014.
Yeah, that's pretty cool when you can set a court date a year in advance of the offense.
That or it didn't get reported to the FBI, just to the courts.
They just put the wrong year on the
See, if you
application.
look at the bottom, probable cause,
typed
second day of
in.
September 2014. They just have the little data.
It's just a year behind.
We do with that one this morning, it was on probation.
Oh, they issued. Simple domestic. Oh.
Or we bring them before you.
Oh, I thought you was gonna say it's why we make the big bucks.
I was, but I decided not to.
Yeah.
Madam Chairman, I make a motion that we grant this application for employee registration.
Okay, we have a motion by Mr. Roberts to accept this employee registration application. Do we have a second? And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Okay, now we're going to move on to the next to the last one, M17. It's going to take you.
Madam Chairman, in looking at this record, it would be, in my opinion, that the length of this record and the significance of the offenses involved would certainly bring me to the conclusion that this person is lacking in good moral character, and therefore I would make a motion that we deny this particular application for registered employee.
We have a motion by Mr. Roberts to deny this application. Do we have a second? Second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed?
Kim, can you give me was it the 1 year in prison for facilitation of theft?
It, quite honestly,
I
it
think
was
it's
the number and seriousness of the
combination of
offenses
all.
involved. And over a significant period of time as well.
Not that you don't have grounds.
I understand.
All right, then, you ready for the one I handed out this morning that didn't get scanned?
The 3-pound case
Yes, the
load here.
3-pound piece, yes. Records are entire transcripts, which is what makes that look so big, but there's quite a few charges listed also.
So, I knew it would have to be last.
That we only needed 5 years of criminal history.
The law implies that.
Yes, your statute does that. 48 months, it says.
It's all their charges, any arrest. But if, and a lot of these companies,
entirely wrong by making that statement.
Is there a discussion about the length of time?
Yeah, the 48 months.
And that's under what statute?
The application procedures.
Said they have
It
to
says they'll
disclose
provide
48
a
months.
statement of all criminal all something from their residences for the past 48 months, and they read that.
I agree. It does ask for 48 months in the background, but it doesn't from looking at
no,
things farther in the past. It's just what they have
it's-
to provide, right?
It's easy to
Right.
misinterpret.
I can see where they get confused.
See if I have any information on it.
Other letter without the
Same guy.
certification number. Yeah, it is.
That the one from AMP? Got it in the body of the.
I, Dave Bowen, number 1456.
Yeah, that's, I'm sorry, I didn't see it in there.
Then he gives both.
Very similar. Find something that was 14 here.
Murder in the first degree.
Mm-hmm.
The property of another person.
Because I'm gonna be writing notes.
Wouldn't want him in my house.
Doesn't, we asked that at times, but it really doesn't matter.
He'll be gone in 30 days.
With did willfully and unlawfully attempt to take, possess, or injure, or whatever. Part that comes after it, you wouldn't want him in your house.
All convictions, but there were quite a few.
Madam Chairman, I make a motion that we grant this employee registration application.
We have a motion by Mr. Roberts to grant this employee registration application. Do we have a second?
Well, I would confess I kind of had to hold my nose when I made that motion. Just looking down through the list of offenses here, first of all, most of them were under the age of 21.
Based on time.
Certainly all of the earlier ones were under age 21, with the exception of the DUI in 2012. Most of the rest of their DUI in Phoenix in 2007. The other ones all over 10 years old or thereabouts. There's nothing here that I see that would be a serious bar. And then considering the that 10 years of age difference between the when the offenses were, or primarily when the offenses were charged and convicted, as opposed to a 31-year-old individual now. I just don't see him as a threat to the general public in state Tennessee, and so that would be my thought process.
We have a second on Mr. Roberts' motion. You did, I'm sorry. We have a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed?
Nay.
And one nay. Motion carries.
I believe that excludes, finishes all that, thank goodness. We're moving right on now to Exhibit N, which is going to be the apprenticeship discussion.
Part of the discussion.
Those are the dead ones, I think. Two of them? Yeah, mine and yours died.
Yeah.
Misbehaves.
Well, you're not too far from being, you've got that.
Yeah.
Mr. Roberts probably gonna need one real
Well.
quick too.
This one's still working.
Here's one more. We got enough for now. Is yours okay?
I'm good, yeah.
All right.
Maybe Tony, or attorney can help us on this apprenticeship.
Oh, yes, I am. I'm
Explain it
sorry.
more.
I'm not. I'm gonna drive the bus on this one.
Are you going to?
I am.
Okay.
I think I'm gonna try to help. Is what I'm gonna
Thank you,
do.
thank you.
No, yeah. So I think when we had a discussion last time, the discussion revolved around the legislature has, asked boards and commissions to pass rules program or see if it's possible to pass rules for an apprenticeship type program to get licensed. And I brought to you all last time talking about there's evidently some national organizations that have similar type apprenticeship programs and whether or not those could be looked at as satisfying the requirements for licensure. And I think this is under our licensure provision that allows for a national training program that if you have I've been looking at this and I think a rule could pretty already what the statute is, which is basically that that somebody they could satisfy a national training program by having completed a nationally or provide that to the board for review, so long as they have 5 years experience in the industry. And I think that would say, given that you already allow for nationally recognized training programs, an apprenticeship program could be a nationally recognized training program. But regardless, they would all come before you, and the rule could state that my suggestion.
Aimed at in place of the qualifying agent test, I guess it would be
Well, just for DQA licensure requirements, none of the further testing requirements or whatnot.
The comments towards an apprenticeship program really have not as much addressed the DQA situation as it has just someone being employed in the industry, which would be one of our registered employees. Because for all intents and purposes, the a registered employee would be fully employed within the industry. Now, and not necessarily an apprenticeship program directed towards the DQA. I mean, I think we're shooting at a target that's higher than really is intended. The General Assembly, as I understand it, was interested in making employment more readily available to people. There are a lot of industries where unless you have gone through some sort of a journeyman program, some sort of apprenticeship program, you can't even be employed in the industry. I'll take an electrician as an example. And in many states, especially where you have very strong union participation, in order to be an electrician, you have to go through an apprenticeship program that can run for years. In many cases, run up to 5 years before you're recognized as an electrician. That situation doesn't, our industry really does not have a significant barrier to someone coming into the industry, as a registered employee and being employed in the industry. So that, if I understand correctly, the desire on the part of the General Assembly really doesn't fit our situation very well. We don't have the barriers that many other occupations have. Now, we certainly want to comply with what the General Assembly is asking, that there be some sort of an apprenticeship program put together. The Electronic Security Association, of which we have good representation here in Tennessee, with the Tennessee Electronic Security Association, does have an organized apprenticeship program that I think is if I understand correctly, has been used to some extent, especially in the Memphis area. I'm not aware that it has been used very widely in other areas. I mean, it's certainly available, but I just don't think it has been widely used. Now, there might be some way we could recognize that program. There may be some other programs out there that I'm not aware of that, again, would provide entry into the alarm industry. But again, I think really our industry does not have the barriers that many other professions or employment situations would have. So
I think what I know that from my understanding how they have done it with some of the other programs, to give you I guess some context, is how they've done it is that other programs giving out licensure, prime example, cosmetology. To be a cosmetologist, it takes 1,500 hours of school, which is roughly a year's worth of training. And the legislature, I think the board was a little bit resistant or whatever. I think I'm stating that correctly in the past. So the legislature just passed they passed the law that says, oh, if a school would like to, a school can create this apprenticeship program, and those students can do 750 hours in class and then 750 hours through apprenticeship. So now, instead of doing the 1,500 hours at the school, now they have an option, but the school doesn't have to do it. It's not mandatory. So I know the legislature was looking at so that people while they're in school can actually work. Work while you're in school is kind of where I've seen it. They wanted to get people out there into the workforce and be able to earn an income while they were training. So when we were looking at this program statutes, like we're looking at all of them, I agree there was a lack of any actual difficult requirements for an employee registration. It's the way I see it. It's you just get the registration. You have to require the education course within the first year is the only requirement there. So an actual apprenticeship program could actually be overly burdensome to the statute. It could actually run afoul. So we kind of thought, well, I think we could say with all honesty to the legislature, oh, for this license, it doesn't actually apply to what your intent is. And they would kind of be in agreement with that. There's a lot of other programs where all you have to do is submit an application and a fee and you get a license. So it doesn't really fit in there. So when we looked, the only other license was the DQA. And so the statute in itself can't be overridden by a rule. It is what it is. The statute, only the legislature could really change the makeup of those requirements. So under your statute, you have the 3 types of education requirements for the DQA, the 4-year degree, the 2-year degree, and then it seems like this national program. I really feel that that an apprenticeship program could be one of these national programs. So I think under the statute, it may actually still qualify. But I think the legislature was looking for compliance would be in a rule just stating that. And I think what you said earlier, Mr. Roberts, about the ESA is that you could state a rule that doesn't just incorporate their program, but potentially open the door for other ones, which is anyone who has a nationally recognized apprenticeship program. And I even think maybe a state program that is nationally recognized, that if they graduate from that, so long as they have 5 years experience in the industry, which we can't get past what the statute says, then they could come before the board and present that to you all for your determination as not whether or not they would qualify for a DQA.
Locksmith licensing program that's under them go by what you're talking about. You submit an application. You do have to be fingerprinted though, just like you do with this board. Apprentice, which runs parallel to the registered employee verbiage, I think. And then by the time you've got your 5 years experience under that qualified agent locksmith, you can sit for the exam. Seems like that's exactly what they're wanting
But
to
do
do.
these individuals have a problem getting a job?
I'm sorry?
Would these individuals have a problem getting a job with the company? You're gonna bring them on as an apprentice and, I
No,
mean, if
no.
you bring them on as an apprentice,
We
for,
sort of already
to
have.
become a
background
qualifying
check.
agent, you're already the qualifying agent, so there wouldn't be any competition. I don't understand it, actually.
The problem with an apprentice, again, I think I've kind of addressed the issue of an apprenticeship type program on the registered employee level, and it really is it doesn't fit our situation very well. Now, on the other hand, if we would look at some sort of apprenticeship program focused on a DQA or a QA level, we've got requirements that are not strictly speaking an apprenticeship program, the years of service and the education program, that kind of fall in that category. But the idea of a DQA or a qualified agent is that this is a person that is technically qualified with years of experience to supervise, not to be employed in the industry, but to supervise the operations of a company or a number of other employees. And I'm not aware of any real apprenticeship program that is focused on building supervisory people. Most of the apprenticeship programs I'm familiar with are oriented towards bringing someone to become an employee in the industry. And so I really think that we should not try and focus an apprenticeship program towards the QA. And I think de facto we virtually have that anyway, because of the years of experience and the requirements that are set up to be a QA through multiple paths. But I don't think we should look at an apprenticeship program to move to the QA level, but rather an apprenticeship program to move into full employment within the industry.
For like an employee registration, an apprenticeship program, the only thing I see difficult in that is that it doesn't appear that there actually are many requirements to become registered as an employee. So
that's the reason I say it doesn't fit our
you're right. I
program
mean,
very
that's the issue I see is an apprenticeship program potentially would be overly burdensome in
Well,
there.
there is a requirement already for level 1 within a year.
Other than that, yes, I'm sorry.
So,
other than that, but
I mean, if it was somehow in lieu of that,
right, and that's what we couldn't do. See,
it could also make an apprenticeship program where it was longer than a year. I mean, at this point, they have to get level 1 within a year, but it could be a longer term. One thing that would be good about an apprenticeship program gets back to prevailing wage, and I don't know if without it being officially part of the state licensing is an apprenticeship program still count towards prevailing wage, and that is an obstacle for somebody getting in, someone that's doing a lot of government work, and they want to hire an apprentice or a helper type person. Right now, there's no way to pay someone other than at the highest level compensation you have to pay someone as an electrician to do a prevailing wage job to install an alarm. But if there was a way to have an apprentice, that could actually open up jobs for people. But I don't know. Do you know, Ken? Can you?
Well,
use
that was
apprenticeship program?
that was the purpose, or one of the purposes of an apprenticeship program was in order to allow people into the industry again in wage scale jobs or in particular situations that are more prevalent outside the state of Tennessee where union membership is required. An apprenticeship program really allows people to move into the industry with a minimal skill set and at an appropriate wage level. In our industry, the barrier to there are very few barriers to becoming an employee in the security industry. It's kind of like setting up an apprenticeship program to be a ditch digger. There's not much of a barrier there, and so an apprenticeship program does not fit terribly well. I think that we could certainly input some language into a rule that might point towards an apprenticeship program of some sort. Well, certainly, if we could come up with some language that would be appropriate for that, we could do that as a rule. I wouldn't see I wouldn't have a problem with that.
Yeah, that's what I would like to bring to you all at the next meeting. Would be some draft language of a proposed rule that would basically, that would basically indicate that under the statute, a national training program can be an apprenticeship program, a nationally recognized one. But they'd have to come before you all so that you can become familiar with the curriculum and criteria and what they've actually done and approve it.
What's a real life situation? Who would actually be taking advantage of this?
Here's what I mean. Honestly, not being in the industry, not being in the industry, what I can see just by reading the text is that you would have someone who would be under this apprenticeship program. They would be an employee at an alarm company. They would be under the apprenticeship program, and that company would basically agree, yes, we will be part of this apprenticeship program and ensure that he's doing X, Y, and Z for whatever credit that he receives. And then after he finishes that apprenticeship program, having done that with his employer, and so long as he's satisfied 5 years, then he could come to the board and be a DQA, not necessarily for that company, but for another company if they wanted to start their own company or whatnot. That's
What QA is going to want to put an employee in direct competition with them?
Well, I mean, I think the legislature doesn't generally look at, questions regarding competition directly from one to another. That may be one of the first things that you can think of, but I can think of, people who are electricians and things like.
Another office. You may want to have.
already do that.
What if we took
Just a second.
You don't have to
I
participate.
believe that a registered employee can upgrade to a qualifying agent
Yeah,
if he
whenever
meets
they
the
want.
requirements right now.
Whenever
5
they
years
want.
experience.
But the employer doesn't have to sign on saying, "Okay, I'll help you go into."
Oh.
competition.
But when you become an employee,
know.
you're training
So I
that
don't know why
individual
they
anyway.
sign into a program.
Right, so I don't.
Why would you have to?
This wouldn't be a requirement. It wouldn't require them to sign into the program. If there was like a nationally recognized apprenticeship program, part of those apprenticeship programs would be that you would have to do that apprenticeship through a company that would be willing to do that, or part of a list of those that do that.
They're already
Hang on
doing
just
that.
one second. I want to make sure I'm hearing what I'm hearing. Even if they become an employee of an alarm company, they're going to have to be registered anyway. They're going to have to do the background checks, the whole deal anyway. They're already going to have to complete 5 years if they want to become a DQA anyway. I guess my question is, what is it that you're proposing that's any different than what we already do?
What you have right now is under the statute, with those 5 years experience, they also have to hold a certification by a national training program approved by the board.
That's
Correct.
the QA's responsibility to get them in school before 30 days is up. That they can become a QA just as soon as they fulfill that 5 years. They're already in a program just as soon as you register them. They start their program, basically.
Why
Their
don't
apprenticeship
we
program.
do this? I think we could debate this at some length. Why don't you put together some draft language and let us take a look at it and see where we can go with it? Again,
Get some government funding for an apprentice program now. We'll get some traction with that.
Pay us to pay them for 5 years.
Probably do some
You
comments
can have
offline
it.
about that.
let's put together some draft language.
The only difference between your alarm employee registration and a locksmith apprentice,
The words,
they
exactly.
didn't use the word locksmith registered employee, they used the word apprentice.
I just
It
said
really
that about
is.
20 minutes ago.
Why don't we
You
put
did.
together?
I was trying.
Why don't we put together some
You
draft
sidestepped
language?
me, I
No, it's
know.
all right.
I mean, could you just change alarm employee to alarm apprentice?
It made somebody feel good.
Really?
I'm not sure that the legislature is looking for, 100 people to jump on this rule and take advantage of it. I think that they're trying to instill that there is a rule out there that could be taken advantage of, if somebody wanted to do that. So
I don't feel like they understand that they're already in a program. As soon as we register them, there starts the tick.
General-
clock ticking.
The General Assembly is looking at not our industry, but as the workplace as a whole. And there are a number of industries where there are significant barriers, experience barriers, for example, in order to hold a job within that industry. I've used electricians, you use pipe fitters, you use steam fitters, the list goes on and on. There are a number of skilled situations where you have to have training in order to be in that industry. Our industry really doesn't fit that, but the General Assembly looks at the broad picture, not our industry. And if we can incorporate some language, it would be reasonable. We don't want to thumb our nose at the General Assembly and say, well, we're not going to do that. It would make a lot more sense to try and accommodate. First, we understand what they're trying to do, and then try and incorporate some language that would accommodate what they're saying. But when you get right down to it, basically it's a shoe that doesn't fit our particular foot.
Right, and I don't necessarily disagree with that. We're just trying to see where we could get that language. So we'll have you, we'll provide you all with some language, proposed language at the next meeting.
It sounds like I'm in the minority, but I think it's a good thing. It sounds like it's not something that you would have to necessarily do. You could still have the regular path of bringing employees in that we've always done. But if we had an apprenticeship program that didn't require level 1 training in the first year, or that was the apprenticeship program was the national training, I mean, you would have another option. You don't have to do that, but it could be.
It's so you hire us and she signs on the apprenticeship program and I don't. In 5 years, either one of us can go sit for
And
an
I'm not talking
exam.
about to be a QA, but the main difference I'm talking about in those two applications were, one of them you could go through the apprenticeship program and do the stuff in the national recognized job. The other is having to go to a level 1 class that's not on the job. I mean, it's not a large hurdle, but I don't see why we couldn't do both.
Scott brings up a good point. We've just talked in terms of a 5-year apprenticeship program because they're pretty common. But frankly, there's not any necessity for an apprenticeship program. It could be 5 years. It could be a 1-year program. We could set up an apprenticeship program, call it an apprenticeship program that includes something equivalent to a level 1 class, and I'm using a generic term there because we've approved a large number of classes that are equivalent to that. And say basically put in there that an employee can work as an apprentice for 1 year. During that period of time, would complete the level 1 equivalency as an apprenticeship program, and then be recognized as a full technician in the alarm industry.
That's going to make a lot of people upset.
What's really
What's the doubt?
They can get their QA license in 1 year instead of 5.
No. Employee, registered.
They can become an employee.
Registered employee.
So make the first year of registration.
Go through a
an
1-year
apprenticeship,
school before they
and
get
then
registered.
move
Exactly.
forward.
Well, what we're doing is basically we're just putting a name to the requirements we've already got
Graduate
established.
From the apprentice program, you have to complete the level 1 or the equivalent, which
You
is
got it.
required in a year, and then you would move into a registered employee position and work. They'd have to, and we'd have records.
Why?
Well, I'm not.
I'm sorry, but I just see a new employee sitting here somewhere.
No, they would apply for an apprenticeship, and then when they completed that year in the training, they could apply to. But it isn't a huge one.
It's a cost change.
Okay, if they're in the apprenticeship program, who's responsible for them?
The company they work for.
Well, not if they're not a registered employee yet.
If
But
they're an
then-
apprentice and they've been through a background check, they're gonna have to apply, just like.
How hard we have to try to explain our rules to people that's been enforced since new rule that we got to try to explain to them.
I'm just, it doesn't sound half bad. I mean, they gotta have that
Let's-
training with
You
them.
answer
Let's-
the calls, it don't bother me.
Let's put
You answer
together
the phone.
some sample language and we'll take a look at it. Let's think in terms of a 1-year apprenticeship that would include a nationally recognized training program, and there are a number of them that's been approved by this board. And then I think we would show good faith in trying to meet the General Assembly's requirements.
Bring that.
Everybody that applies as an employee gonna have to sign on as an apprentice, or is it
No,
just?
this would be another option.
No.
They could.
What's it
Gotta
gonna
separate
accomplish other than
categories
calling it an
again.
apprenticeship?
That's about the
More
extent
work.
of it.
More,
The General Assembly happy.
it's just,
If it makes them happy, but it does have
It's
a
just right
purpose
here.
for.
Well, it does, but if you're not gonna require
More
that
paper
1 year of
shuffle.
apprenticeship prior to being a registered
everybody.
employee, it's just,
They can move into a registered employee, but
do you
they,
fix it where the apprentice can apply at 17 and give them 1 year to work before they turn 18?
It would require a statutory change.
So is this.
No.
why do they
No.
want to change something we already have?
Yeah, you can't, I mean, you don't have any provisions in the law for them to apply as an apprentice.
So you're gonna have to.
I think we could do that by rule. I don't, I mean,
They're
we're not
registered.
changing,
They're
the-
already the
we're not changing the requirements. I think we could do that by rule. Let's see what council comes up with.
If I hire, let me ask this, if I hire a new locksmith, what are they called?
Hired a what?
A locksmith under my QA license, what are they called?
If he passes, he's gonna be a locksmith. If
No,
he
they're called-
qualifies.
If I hire him on as a new
He's a
hire.
locksmith apprentice.
You have to tell me you want to put him on as an apprentice.
Apprentice.
Okay.
And
They'll
after
do a
he
background
completes
check.
X amount of time under me,
But he doesn't, it's not required to be an apprentice to be a locksmith.
so
he
if
just has
he's a
to
new
have
hire,
40
he's
hours
an
of
apprentice
experience.
because he don't have the knowledge yet.
One of the big
Yeah.
pluses here, we've been getting involvement with Metro Public Schools. If some of these got to be an alarm apprentice at the age of 17, the schools would support it through their technical. That would be the only way I could see this making any sense. But I
They're
would.
supporting that now for security guards.
Yeah.
They're going ahead and letting
Doing
they're doing the applications at 18. They're seniors. There's a program. What is it? Criminal.
They're
They're
having it
applying
in
in
their
criminal
criminal
justice,
justice.
and a part of that is getting the registration with our office. They'll be ready when they graduate to at least start working in some field to get the experience.
They've already had the training and they're getting grants and paying the
And,
application fees.
Depending on what the change to the statutory language would be, I personally would not have a particular problem with that. In fact, the idea, that sounds like a good suggestion. But again, that would require a statutory change, and maybe what we want to do. I wouldn't have a problem with that.
Like that, open the door so somebody at an entry level, right out of high school, it's been taking
Sure.
I know Metro Schools would be interested.
What we may want to do is take a two-step program. One is look at a rule change that would put some language in there that would technically make provisions for an apprenticeship program, but I mean, we can't change what the statute says without going through the General Assembly. First step would be to change the rules to accommodate what the General Assembly has asked us to do. And then secondly, in a longer-term situation, look at some sort of a statutory change that would allow that. So two-step program instead of one.
Right, and every year we provide the department with a package of any statutory changes that the board may want, and the department looks at it, see if it would be taken up as a package to go be supported through the governor's office. It gets filtered out by a lot of people, but generally we find that if you have a good reason for it and all that, it'll be given consideration. And
we'd want to do something that would be acceptable to the industry as well.
Right.
And if we decide we want to do it, and then the general industry says no, we're not going to do that, then it becomes kind of like pushing a rope.
Right, and we found that things that support the governor's policies are generally looked on favorably and go through the office quite easily. So. Yeah. I don't think so either.
I think if it were reasonable, I doubt that we would have anything other than support from within the majority of the industry. There's always going to be somebody that's objection, but I think if approached reasonably and the industry was brought on board with us, that we could get good support out of that, and I don't see a problem.
Some of us have children that age, and they can't work because they're not able.
Yeah, true. Let's look at this two-step program then.
Are we ready to move to the next item?
Yes, ma'am. I believe that would be the education report.
Oh, I don't need it for that.
I sent out several random courses to different people, and then I sent everybody some of them. So none of them were really complicated. Everybody a copy of Sterling Barnes, the Eastern Idaho Technical College, the NEC code update that he took.
Yes, I had a problem. I had a problem with that. I could not, in good conscience, recommend approval of that for 16 hours of continuing education. I've taken a number of NEC update courses. I can't recall any that lasted over a day. I understand, but what I'm saying is if it's an update course, then I would have a hard time seeing that it would take 2 days to provide update information. Now, on the other hand, if it is an NEC course, which could easily take a couple of days.
Well, it was at a state college. And the transcript showed, here it is,
I printed out the information that I had.
It's on page 4, because I questioned that too. And it says, times on it. It was a 2-day class, and this is just for his continuing ed to renew.
Right. If you'll also notice the certificate of achievement saying where he indicated that he passed the course is dated on the first day rather than the second day. It's dated October the 7th, which is the first day of the supposed class. I would have a hard time recommending approval of an NEC update class for taking 2 days to accomplish.
Well, can you approve it for 8? 'Cause
Yes,
it's
I can
only
approve.
got
I can approve it
April,
for
May
8
till the
without a
end of the
problem.
month to get 8 more hours, so.
In fact, I would recommend approval for 8 hours. Do we need to make that a motion? I would make a motion then that we approve the NEC update course as provided by the Eastern Idaho Technical College for 8 hours of continuing education in the burglar, fire alarm, and well, continuing education isn't categorized, but it certainly would have application to the burglar, fire, and CCT industries, or classification as they've indicated on the application. Motion to approve for 8 hours.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to approve the NEC update. As Mr. Roberts read the particulars into the record, all in favor voice by saying aye.
Aye.
All opposed?
The next course, I did send out to everyone. I would only recommend that for continuing ed. Did anybody, I mean, they're already around.
I personally felt like 4 hours of continuing education for that particular course would be appropriate and would make a motion to that effect.
Well, let's do one at the end. Did anybody
Okay.
have any problems that I sent? Called IP networking dash installation. It was a 1-hour continuing ed course.
I got that one, but I didn't get that one.
They were all in one email, Karen.
The one that he just talked about with the 4 hours?
No,
I read that one.
I sent it out on June 5th.
The networking one, I could have missed it, but
Well, I
I'm
sent
not
that
saying
one
I
out.
didn't get it at all.
Went to everybody. And then this one for Jade. Actually, you're the first.
I'm not saying I didn't get it. I didn't read. I missed it.
Okay, well, these were 2 1-hour courses by an already.
They both look fine to me.
Beth, I think I got one of those, IP networking installation,
Yeah, they were.
1 hour of continuing education.
Yeah.
I would recommend approval of that without any hesitation.
I've left one off here, and I don't know if you reviewed it. I sent it out at the same time. It was the Extralis Vesta air sampling smoke detection system. 8-hour course?
Yes, I have that, and I would recommend approval of it for continuing education as requested.
I would too. At first, I thought 8 hours was a lot, but I looked into what, and it is an all-day class. It's very specific on that.
And I looked at it the same way. I had the same reservations, but looking at it, yeah, that's an 8-hour class.
Okay. The other courses that were sent out were all submitted, I believe, by Rod Warren with Amster Green Management Group. The first one is, and I put these all under Amster Green Management Group because there's several different buyers that provide the equipment, and I just put them all under AMG. Introduction to gas and carbon monoxide detection for use with fire and security systems. It's a 2-hour continuing education course. I sent that to Scott.
It looked good. It was at first I thought 2 hours on gas detectors, but it was rather in depth and more specific than just a simple carbon monoxide detector.
The second Mercuro course I also sent to Scott. It was advanced gas detection design and deployment.
They both look good, yeah.
Then I sent one to Ken for Gym Electronics, Connect to Success.
I would recommend approval of that.
All right, and to Keith. Surveillance, 2 hours.
Yes.
Technology video IP security deployment training and applications. It was a 2-hour. Right now, the recommendation is to approve all the courses as submitted.
Well,
the first one we voted on
Yeah, we voted on the first one. The other ones were
as
submitted.
submitted, yeah.
We need a motion for that, please.
One exception, didn't you, where you were not doing employee training on one, or?
Yes. I announced that when I announced it, but yes, we're not gonna approve that for employees.
For continuing education, I so move.
Second.
Okay, we have a motion and a second to accept all of the continuing education and training packages as submitted, correct?
Just
One
as
exception.
for the continuing education.
For the continuing ed only. We have a motion and a second. Go ahead.
Did y'all vote on that? Or
No.
am I jumping ahead as usual? Sorry.
All in favor, voice by saying aye.
Aye.
All opposed?
In such a hurry.
Go ahead.
We've been getting a lot of certificates for certified alarm technician level 2. And there really is no. Like their fire alarm designer certification. But they give out a certificate that says you're certified alarm technician level 2. We're looking at this going, wait a minute, they got rid of level 1 and 2. So I finally contacted NTS. And what you have to do to get that, and Pat Allen is always extremely helpful, but to earn certified alarm technical level 2 status, a student must hold certified alarm technician level 1 or higher, have 24 months field experience, successfully complete the advanced and the fire alarm installation methods course, or the online equivalent. And so the people that are sending us these certified alarm technicians, now we can send them a notice back that we need their. We were extremely confused for a while. And this is really similar to what they used to have with level 1 and 2 before, but this is more of a. At least you'll kind of be aware of what it is. I'm a certain.
What you're saying is you need the support, you need the stuff that got them there.
To get it. But we can't take it for continuing ed because we don't know when they completed all that.
They could have used in a previous year, and then, yeah. So the level 2 certificate itself doesn't count for anything.
It's not a training certificate, it's a certification level. So if somebody complains,
Take all the parts of it, just not the.
and I just wanted y'all to be aware of that, because I knew NTS was going to some of that kind of stuff, more similar to what NICET does. So.
That's what they're trying to do, is move towards certification.
Yeah, and it makes sense. It's just, the first time I saw one, I'm like, wait a minute. So, that is the end of the education report. Thank you.
Okay. Course review's been approved. That was Exhibit O. Any unfinished business by anyone?
Keith? Yes, this is unfinished business, this part right here. This is, I want to pass this. And it was real hot and heavy on the security industry. Drones, as we had talked about, it was a very hot. Knowing the hotel is probably already booked up. Laurel, pardon me, and that she'll. And I will be going this year.
This is just similar. There's a organization that's parallel with ALOA, Associated Locksmiths of America, and Dad and I just joined last year. It's called International Association of Investigative Locksmiths. And
I've heard of that group. They do training.
Yeah.
They do a lot of forensic training. And
Yes, they're forensic. They teach forensics in locksmithing, and not only locksmithing. It bleeds over a little bit into alarms. The pamphlets and articles that come out in the pamphlet that we get, if they allow me, I'll let you make copies and hand them out to the board and let them read them. It's just informational, but I'm assuming it's a lot like this.
Well, actually, it's more training. This is probably more discussions, but.
Yes, this is the
You learn either
International
way.
Association. They try to get federal
That
laws
forensic
passed. They're the ones that try to help each state pass their laws as well. But like I said, just let me know if you're interested in it, or call them, sign up. And I bet you have to be a member or a non-member or associate. You would be considered associate members. That means you just don't have the right to vote. But when I attended the meeting, it touched on all 4 of our programs with security.
Have any more unfinished business?
I had something
Okay.
to ask about. Sometime back, we had all kind of brought up and discussed the idea of changing our status from on the board that we are here from just regular board. Further traction on that, or was that kind of left where we left it?
That was kind of I dropped the ball on that. I was supposed to write a letter, which I wrote a letter, but I didn't know who I was supposed to address it to or just what. But where would I direct that? Should I get that to you or?
Send it to me, and I'll see that it gets moved up.
We don't really want it. We just want a state ID.
I
right?
told him that.
But-
I don't think you really care about the per diem as much as you do some kind of identification. I haven't gotten a response, but I should have checked on it before we had this meeting.
Isn't the per diem or the lack of per diem in your law?
Yes, that's correct. It is stipulated that we serve without compensation. However, the state in other areas of the statute provide for compensation of expenses, which is appropriate.
And the only reason you don't have state
It would seem like that could be done administratively, frankly.
We'll check on that again. Thank you.
Okay, any new business?
Up some new business. I wanted to talk to the board about extending our board meetings to 6 times a year. Instead of, I believe we do look like we are financially sound. It does appear that we are going to, from what we can tell in the office, going to have more business to do that would keep us here a good half day or if not longer.
I think it's a good idea. I think because of what the General Assembly is likely to do in terms of our continuation, it needs to be an even number of meetings. But, yeah, I mean, just looking at the amount of business we have had to do today and the length of time it's taken to go through it, having 1 or 2 additional meetings throughout the year makes more sense to me.
It also helps y'all do business more timely too, right? You
Sure.
can, it helps you to complete business more timely.
Oh, yes, I have
Even
one
if
of these
we,
registered employees. Right now, we're holding the applications every 3 months.
Yeah, for instance, the people we approved today, some of those
Already been approved.
applications could be 4 and 5 months old.
Mm-hmm.
I
Have more
understand.
Often, didn't we?
I mean,
But it's a
Cindy's been
possibility.
pulling them out as
Yeah.
soon as they come in. Let's look at this one. So, I have one question on that. Do you also want to continue to schedule the day after?
It makes sense.
So it would be a meeting on Thursday, meeting room reserved for a possible hearing on Friday.
Yes, it is, and we will have to turn that in.
Yeah, I've gotta go ahead and
It helps the
schedule your board meetings.
litigators, like we had one scheduled for tomorrow, but you heard it this morning and took care of that. And give the list, what we have to do it like a year in advance of
Yeah,
our meetings.
So I'm fixing to start
So
working on
this,
next year.
yeah, she's gonna be working on next year, so we're gonna increase our board meetings.
I
And,
doubt you can tell us with any accuracy, but what is the chance what's the percentage of the chance of those 51 going to actual hearing? Do we have like a feel on whether they're gonna be settled, or are they gonna go to hearing, or what?
We don't even know, the 51 haven't even, they
Open,
might not even be a hearing. I think
we
we've got
don't know.
4 pending.
So we don't
hearings.
have.
I
they're
couldn't
not-
tell you that because you have not heard these cases.
Okay,
yet.
okay. All I was gonna say is if it gets to the point where it's necessary, I would be willing to do a Wednesday, Thursday meeting and a Friday hearing, Wednesday hearing instead of making more trips appear.
The problem that they're having, and I'm sure our council can address that, is getting the administrative law judge, or getting a judge.
So if you would like to, what happens is, so that you all know, is that roughly October of every year, we submit to the Administrative Procedures Division a list of that the boards and commissions are going to meet for the next year. And actually, it's the dates that you all would like to have a formal hearing on. So usually be like your day after. So they do that calendar. Actually, it's about end of summer we'll do that. We try to get the dates set by October. So once they set those dates, they can't change them. So the dates for this year all the way until this October are set. But for after the first of the year, those are up for grabs. So if you all wanted to meet 6 times a year, after January 1st, then whatever, and do 6 days for formal hearings, we'll ask the Administrative Procedures Divisions for those dates. And they do.
That is actually what you have done in the past. We meet on a Thursday, the formal hearings are on a Friday. So from what I'm hearing, that's exactly what we want to do for the next year. We're just going to
We can find rooms.
Can we dodge March and June some way? That's the basketball month and then the fanfare. And I like to never find rooms for
But
those 2 months.
We had to change the
if we
dates.
used
Yeah, we had to
alternate
change 'em.
months starting with February, then you would avoid those 2 months.
Yeah, but we have another board that has to meet in the month that you're not meeting.
What I'm saying is that, what I'm saying is,
their
Some
turn.
months where we're just gonna have two board meetings. There's no-
well, but what I'm saying
The
is,
reason we did that was to kind of
Help us to.
even it out.
Right.
if we had it every other month and started in February, then we would be skipping March and June per your request.
In February, sometimes we can't have the meeting because of the weather.
I understand that, sure.
I'm pretty sure we've already got a hearing scheduled for the September for next meeting. And if we were shortening our meetings, they could actually schedule hearings starting at 1 o'clock on.
They do. They'd rather you lock in that date, you know, because, and then they'll commit that date to us, but that's what we end up doing. So like tomorrow, that you all, your hearing wasn't here. So what we generally would do sometimes is say, well, the board's not going to have a hearing that day, so we'll just open it up that people could come in and just with the administrative law judge and just go ahead and use that date. So we still try to use it, even if you all don't use it. Yeah.
Do we need a motion for, I believe we might need a motion in that to increase our board meetings.
Did we have a motion to decrease it from before? I don't think we did. I think
I
it
don't
was
think
just
we did
done
either.
administratively.
Okay, we're
happened.
doing it, that's fine. I just want to make sure we're doing everything.
Yeah.
properly.
Okay.
So that is start next year, January 1.
Like I say, I think if we start with February, that would probably work out better.
Have us meeting, and again, I'll try to keep it.
Even months.
When do we usually, is it toward a certain day of the, or week of
I
the month
usually
or
try to
something?
schedule it third week of the month, I think, but
We schedule it a year in advance.
It really-
It's gonna mean a lot when they change this, but you can meet more than two.
That's okay. I mean, it's just there's certain times, you know, like when they have this basketball tournament in March and then Fan Fest or Fanfare, whatever they call it, last week. You know, that's what we've had to
I'll try
do.
move
We've
it around. I did
changed.
check Nashville's calendar
Right.
before I booked them.
It's
But
a
I
big
mean, you've had
calendar.
to
That's when we had
change.
to realize I had scheduled it for CMA week because
Now, they've already they've already released the dates for next
they
year.
have.
I heard it.
They also announced that Bonnaroo will not be held the same week as the CMA ever again, so, or at least. I mean, there's just so
Different
much
crowds
traffic.
altogether.
Yeah,
Oh,
but it's
yeah.
the traffic. You can't get in and out of Nashville for like 3 days.
All right, any more new business? All minds clear? This meeting is adjourned. See you in September.
Okay.